Listing Lordship. Listing Lordship. Friday Lordship, my lord, matter pertaining to promotion to the post of headmaster Lordship. My lord, respondents were directed to file to reply. My lord, they have not yet filed a reply, Lordship.
Promotion to headmaster, which school?
Yes, yes, Lordship. High school Lordship. High school, BTED Lordship.
When do you want?
Lordship, kindly, it may be on a Friday, Lordship.
Okay, try your luck. Yes.
Lovely.
May I please? I beg to mention listing of an matter on Friday, my lord.
For what?
My lord, for motion, it's a fresh matter.
When did you file?
On 7th, my lord, on Saturday.
Subject of curing any defects if it is if there is any.
My lord.
May it please, your lordship, I am mentioning on behalf of Mr. S.K. Das, item number 19 and 20, both are similar matters, lordship. We are for the petitioner and also taken consent from other side. Lordship, today he has some difficulties. Can it be taken up after 1 week?
After vacation?
No, after a week, my lord. Okay,
In the prayer of
oblige the lordship.
May I please?
the council for the party. Week. Please the matter. Yes.
My lord, I beg to mention for listing to admission matter, my lord. On 16 or 17, my lord.
18th.
18th.
May I please,
I'm-
your lordship, Lordship, I beg to mention item number 25, 26 and 27. These are series matter, lordship.
Yes.
Lordship, can it be on next week, lordship, any date? Mr. K. H. Khondagar appearing in this case, due to his illness today, he is unable to appear. Lordship. I have informed the other side also. Lordship.
The prayer of the council for the party. Yes, after 2 weeks.
Yes, may I please, my lordship, with the consent of the other side, I beg to mention item number 5, lordship. Can this matter be fixed after 2 weeks?
After 2 weeks.
Yes,
Lordship, item number 5, they have not taken consent from us.
Because these are 2020 matters.
from RK Bodua, I have taken consent.
I
the matter is-
petitioner, lordship.
Let the matter reach.
Lordship.
May it please, lordship, I beg to mention item number 29, my lord. We have a joint prayer, my lord. My learned friend is there for the petitioner side, my lord. My lord, let this matter come after 2 weeks, my lord. We both have some difficulty today, my lord.
After 2 weeks only.
If my lord will indicate some date, my lord.
The resistance.
My lord, please.
Wait for listing admission, 16, pensionary benefit.
Lordship, prayer for listing leftover matter, lordship, and day after tomorrow, lordship. Similar petition, lordship. Prayer for seeking Jimma of a vehicle, lordship, only. Day after tomorrow, lordship. And 2 times leftover, lordship.
2820.
May I please, your lordship?
Friday.
Lordship, I beg to mention for listing for withdrawal.
On 13th, not on 20th, 13th.
Lordship, I
Yes.
beg to mention for withdraw, your lordship. The writ petitioner was under suspension. His grievance has redressed to my lord. So,
Kali Ahibo Guru. Okay, tomorrow.
May I please, your
Oblige.
lordship, lordship, with the consent of other side, I beg to mention item number 2 of the daily list.
Item number?
2, lordship.
Yes.
So matter may be taken up after 1 week. Learned counsel, Mr. J. Abedin is having some personal difficulties.
The prayer of the council.
Please, your lordship. Lordship, I beg to, with the consent of the other party, I beg to mention item number 1. My senior R.S. Chaudhary, she is unable to appear because of some personal difficulties.
You have informed the other side.
Yes, your lordship.
For the respondent, standing council. KPS.
Your lordship, if I can get a date.
After a week. Yes, next.
May I please, your lordship, I beg to mention for listing of 6 criminal revision petition. They are all are similar matter. For tomorrow, lordship.
16th,
Lordship, 13.
not on 13th possible. Board is full almost. Even if it is listed, it will not reach. That's a problem. 16th.
Oblige,
Please,
lordship.
lordship, I beg to mention item 23 and 24. Lordship, due to some personal difficulty, my senior Mr. S.P. Das could not come today. So kindly pass over the matter for the day and fix a short day.
Fixed date, not.
We are not giving the date. It will come after. a week.
Nothing matter relating to pensionary benefit last 4 years has been depriving, even continuing mandamus has already been issued by this Honorable Court, Lordship, only consideration of this aspect, Lordship. So Lordship, matter is
18th.
deeply.
Objection.
May I please? My lord, I beg to mention item number 7, my lord. With the consent of other side, this matter may come up on next week, my lord. Well, here, last chance was given to me to file our affidavit. Well, some correction is required. That is why I need one extent.
Let the matter reach.
My lord.
My pleasure, Lordship. Lordship, I beg to mention for listing of a contempt matter for orders, Lordship. In
What is
next
the
week-
urgency in contempt matter?
Lordship, current seller is also not receiving, Lordship, and it was there was a specific direction for release of current and arrears seller, Lordship. He was reinstated pursuant to the Honorable Court's order, but however, current seller is also not being received, Lordship. On Monday, Lordship, next week, Monday.
Okay, on 16th.
Deeply honored.
Lord, to admission matter, my lord, may I pray for listing on the 16th of this month?
Make it on 18th. 16th, there are full.
Oblige.
My pleasure, Lordship. Lordship, as per the formal instruction of my client, I want to withdraw this case.
Second home, second application.
What's your good name?
Mr. P.K. Bhuya.
On instruction of the petitioner. Counsel Mr. P.K. Going. He is learned. He is not present this petition. Counsel appearing for the respondents
1 and 2, I'm appearing for secondary education.
for the secondary education person.
Lordship, I'm appearing on behalf of TC Sutia for Seba, Lordship, respondent number
As
3.
well as standing. As well as respondent seven. Doesn't have any. According to. Previous business and dismissed. Hearing of the case.
Deeply obliged.
Deeply obliged.
Wait, wait, wait. No, this was a read petition challenging the transfer, my lord. It was listed on 6th of 9, my lord. On that day, when I was praying for interim, the respondent took some time for instruction. Even otherwise, my lord, this order has not been passed by district level committee, my lord. Inter-district transfer, my lord, but has to be passed by a committee, my lord. So on that point, they took time, my lord.
Lordship, will pass over this matter for timing, Lordship.
And now, my lord, I am in the existing school where I was working, my lord. But the thing is that, my lord, after this today, my lord, if they do not, my lord, apprise the court, my lord, then some protection is required, my lord. In the former status quo, my lord. I have in paragraph 7, I have stated, my lord, that it was all of a sudden it was passed, my lord, so far related to the petitioner, my lord. And without the, my lord, the passing the order by the highest authority. The highest authority is the district level committee, which consists of the, my lord, deputy commissioner, my lord. As per the Act, my lord, 2020, my lord. So apparently, my lord, prima facie, it is that they have passed all of a sudden, my lord. And the transfer order is at page 22, Lordship will see. Page 22 is the transfer order, my lord. My name is serial number 8, my lord. Deepika Huzai, my lord. Page 23. And your lordship will kindly see that page 27, my lord, is the communication to the authority. There is no deputy commissioner, my lord, or additional. Page 27, my lord. Page 27, my lord. So, my lord, this is one of prima facie case, my lord. There is no communication with deputy commissioner regarding passing of the order.
The school where I have transferred, my lord, that is also around up down 200 km in a forest area, my lord. In a border, my lord, forest area, my lord. Where only 4 students is there. I expect.
Lordship. Regarding the transfer, Lordship, NC's Autonomous Council has formed the Rationalization Committee, Lordship, and as per the Rationalization Committee's approval, these transfers were made. This is the procedure of Rationalization Committee, Lordship. Moreover, Lordship, the petitioner was in the same school since her joining, Lordship. That is, she has herself admitted that from 2000 in paragraph 4, page 5, she herself has admitted that from 2000 till date, she was there only in that school, Lordship.
As per the act, my lord.
Lordship.
Transfer can be on own request. These are procedure. I have no. own
Moreover,
request.
she has taken the ground that she has got a child, 7 years child, Lordship. But
What is the policy of rationalization, Mr. Das?
Lordship,
What is the policy of rationalization? Is simply because a teacher is working for more than 10 years or 15 years, whatever,
Lordship,
you will simply transfer a teacher from one particular zone to another zone.
Lordship,
Or the rationalization means what? If you are doing it for rationalization, for what purpose?
As per the act, they have to do that. 2020.
What is the process of rationalization?
means without the approval of the Rationalization Committee, transfer cannot be done, Lordship.
So I have placed the act, my lord. That is the thing, my lord. The act is applicable to whole of the Assam, my lord. Act, section 5. My lord, first and foremost, my lord, the additional deputy commissioner has to be a committee member, my lord. District level committee has to do it, my lord. That is the competent authority. That has been not been done, my lord. And secondly, my lord, restoration as per the act, my lord.
Mr. Das,
Lordship.
now let's come to page number of the act. Do you have the copy of the act?
Lordship.
Assam Elementary and Secondary Education Teachers Regulation of Posting and Transfer Act. You have that?
Yep.
Okay. Now. Which page in that book?
Lordship.
Which page in your book? Page number in your book. Is it a new book? Which is that book you are having? What's the page number? Starts at page.
Lordship may give me sometime, Lordship. I will.
Well, I have placed a copy.
It starts at page 8. You got it?
Yes, Lordship. Page 8.
Come to section 3, rule 3.
Norms for posting of teachers.
Read loud.
All teachers of elementary school shall be posted by the appointing authority strictly in accordance with the provisions contained in the Right of Children to Free and Compulsory Education Act 2009. Read with the rules framed thereunder and the norm speaks by the government from time to time in compliance with the provisions of the said act. The teachers of the secondary school shall be posted by the appointing authority in accordance with the relevant service rules in force and norms fixed by the government from time to time in compliance with the provisions of the said rules. The place of posting of teachers under sub-rule 1, subsections 1 and 2 above shall be in accordance with the PTR norms as laid down in section 4 of this act. Lordship.
Now, please come to rule 6.
That is inter-school transfer norms.
That's right. 6 to 6 and 6A you read. As applicable in this.
The government and the competent authorities shall be guided by the following norms in respect of the inter-school transfer of teachers within the district. The teachers may be transferred from one elementary school to another elementary school within the district in accordance with the requirement of teachers in the school as per the norms provided under section 19 and 25. Read with the schedule to the Right of Children to Free and Compulsory Education Act 2009 and Rule 21 of the Assam Right of Children to Free and Compulsory Education Rules 2011. Lordship.
Read. D,
The transfer of teachers from one school to another school within the district may be allowed by the competent authority strictly in accordance with the PTR norms. Teacher from a high PTR school may only be transferred to a school having low PTR. Under no circumstances, teacher from a low PTR school can be transferred to a high PTR except under section 9. Lordship, here is the same, Lordship, because here
we'll come back to you. Then E,
the effect of all the transfers shall have to be done during the period of summer vacation in order to minimize academic loss.
F,
The district elementary education officer or the inspector of schools and the district level committee shall take action for transfer and posting of teachers in schools in accordance with the PTR norms and in compliance with the provisions of this act, so that the transfer order can be issued within the summer vacation by the concerned appointing authority.
then read 7E,
The effect of all transfer has to be done during the period of summer vacation in order to minimize academic loss.
F,
The district elementary education officers or the inspector of schools and the state level committee shall take action for transfer and posting of teachers in schools in accordance with the PTR norms and in compliance with the provisions of this act, so that the transfer orders can be issued within the summer vacation by the concerned appointing authority.
Rule 9,
Lordship,
Rule 9.
Rule 9. Power of Deputy Commissioner in case of exigencies for maintenance of proper academic atmosphere in a school or for maintaining peace and tranquility or for safety and security of the female teacher, the Deputy Commissioner of a district, after observing such formalities as may be prescribed, is satisfied that transfer of a teacher is essential for any one of the said grounds, may refer to the competent authority for transfer of a teacher, even from a low PTR school. The competent authorities shall immediately consider such proposals of the Deputy Commissioner and recommend to the concerned appointing authority for issue of transfer order, provided that on transfer of such a teacher from low PTR school, the appointing authority shall immediately post a teacher in that school to maintain PTR norms as per provisions of this act, either by direct recruitment or through transfer from a high PTR school.
Read Rule 12, 1 and 2.
Lordship, 10, 1 and 2.
12.
12. Violation of any of these provisions shall be treated as commission of an offence punishable under this act. Whoever violates any one or more of the provisions of this act shall be punishable with rigorous imprisonment for a term which may extend to 1 year or fine not exceeding 50,000 rupees.
Now, can you tell us what is the number of students in Pelau Nabensa LP School under Maibong W Circle, wherein the petitioner is working?
Lordship,
How
the,
many teachers are there and how many students are there?
the teachers, as per the instructions which I have received over telephone, is almost 8 in that school, in the present school where the petitioner is still working.
How many teachers?
8 teachers.
Students?
Students is, I think, around 20, Lordship.
Now,
No,
the school in which the petitioner has been transferred.
175 students.
Hold on.
Lordship, the schools where the petitioner has been transferred is comprised of around 8 to 10 students, Lordship.
many
And there was no teacher. No teacher.
There is one teacher, ma'am.
That's why, Lordship. That's why she has been transferred to that place, Lordship.
Okay. Now, how many teachers are there in the present school where the petitioner is posted?
Lordship,
8 teachers. You said.
yes, Lordship.
How many students?
175.
Lordship, around
of instruction.
10, 8 to 10 students. 10,
Get the approval, for how many students you are providing midday meals?
Lordship.
For how many students you are providing midday meals?
Then I have to take the instructions,
You
Lordship.
get the instruction, you'll have it
Lordship.
tomorrow.
Tomorrow.
Over phone you do it, or get the WhatsApp message to the office is open.
Lordship,
Number of students in the petitioner is working
Lordship, I will.
and the number of teachers in which the petitioner has been transferred.
Lordship, I will. I will.
And get the authentic report.
Yes, yes, Lordship.
Let it be on day after tomorrow, madam. Tomorrow, some part of.
Tomorrow, ask someone to be here.
Lordship. I will.
Well, till that tomorrow, my lord, your lordship will give a status quo, my lord.
Nothing is there, Lordship. She has not been
Because
joined.
on
also.
last occasion, they have taken.
She has
time.
not been released and she has not been joined also, Lordship.
Even then, my lord, it's a.
Let us get the information tomorrow.
Lordship.
Like.
Earphone touch the video. Earphone to Arjuna. Apo.
May it please your worship. My lord, the petitioner appeared for the selection test for admission to first year MBBS course. Yes, selection test for MBBS course 2024 from Assam State quota in the Tea Garden Laborers reservation quota, and he got selected. Your lordship may now turn to page 97, where your lordship will find provisional select list. My number is at, from top, number is at 6. Page 97, the horizontal page. Anish Yadav, registration number 2577, roll number and others are given in Silchar Medical College.
Yes.
My lord, and in pursuant, then your lordship may turn to page 95. 95 states that within 5th September, I have to go and join the medical college. Otherwise, it will be cancelled. Page 95, Annex 14. In middle portion, all provision selected candidate for studying Assam government hereby directed to report to the principal of for the following terms and conditions 3rd September to 5th September for admission, failing which either allotment shall be cancelled. Your lordship has got it.
Yes.
My lord, then your lordship may turn to page 99, where I reported on 3rd September and my medical test was done. Page 99. And I was found fit. My lord, now your lordship may turn to page 103. One person filed a writ petition against me. The order starts at page 105.
Yes.
And my lord, the order was passed that my admission will be subject to outcome of the writ petition. Page 106. There was no stay order. I went on 4th on the next page 107 to the principal for admission. They said until unless you get a proper direction from this court, we will not allow you admission. They have received the copy also and they are not giving me admission. That is why I am before your lord. There was no stay order, nothing of that sort.
Today itself. Right? At 2 o'clock, you report us. There is no stay order, only direction is subject to the outcome. Right? Inform us at 2 o'clock whether the petitioner has been appointed or not. Admitted or not.
Both are
Silchar Medical College.
Silchar
right?
Medical College. Silchar College.
Inform us at 2 o'clock.
Yes, madam. It will be Silchar Dental College, my lord.
No, medical college.
Medical college.
I am a MBBS. MBBS. That person who filed the case is for business.
Yes, my lord.
At 2 o'clock.
Yes,
He should be admitted.
yes, madam.
May it please your lordship.
Yes.
My lord, the petitioner before lordship, there are 3 in number. They are, my lord, assistant professors in my lord Haflang College working on my lord 3 years.
They mentioned in the morning of
My lord,
item
4.
May I pray for a matter for a time being? Mr. K. Gogoi, he will argue the matter and he is in Lakes in court number 20.
Let Mr. Chaudhary place his case.
In the meantime, let me place the case.
Yes.
Let him place the case.
The petitioners, my lord, they are working under 3F, my lord, since 2001 in my lord Haflang College.
Yes,
And,
all of them are working under 3F.
My lord.
Okay.
Now, in fact, at one point of time, my lord, their services were terminated. They approached this honorable court. My lord, that was set aside, and on the basis of that, they are continuing. And my lord, last extension has been given for a period of 5 years. That is, my lord, that of course we have got it later. That was in December 2022. That my lord, the period has been extended for 5 years. Now, my lord, your lordship may kindly come to the order dated 19/1/2024. Third paragraph, on the next date fix, Mr. Sharma, with reference to the contentions made in paragraph 7 of the additional affidavit filed by the Principal Secretary, North Castro Hills Autonomous Council, Haflang, in the present proceeding, shall appraise the court the extent of power of the said council with regard to delegated subjects, more specifically college education. The competent authority of the said council shall also apprise this court as to the extent of power exercised by the council with regard to the functioning of the Haflong Government College. The said instruction be produced before the court in the written form along with the supporting documents on the next date fixed. My lord, on the next date fixed, my lord, an instruction was placed before your lordship. We are also given a copy. That is, my lord, communication dated 12 February 2024. Out of the PSN. I know. Or may I, my lord?
Just a minute, just a minute.
Has your lordship got it, my lord?
That order we have seen.
No, order is there, but then, my lord, the instructions dated 12 February 2024.
Flag X,
Huh?
so flag X will be my.
My lord, I think that is flag X, my lord.
I am not on this.
It's a communication by the principal secretary, NC Autonomous Council in Haflong, addressed to the, my lord, standing council. Has your lordship got it, my lord?
Yes, yes.
May I read that, ma'am?
Yes, please.
Regarding Honorable High Court's order dated 19/1/2024 in WPC so-and-so, with reference to the subject cited above, I am to forward herewith the reply on the query made by the Honorable High Court in its order dated 19/1/2024 in WPC as per the paragraph given below. The said lecturers have been continuing in their services subsequent to the termination of their services by the Government of Assam on the basis of their fresh engagement by the NC Hills Autonomous Council, wide order number such and such dated 28 January 2019. Their services are not in continuation from the duration rendered by them. Hence, the said lecturers have been continuing in their services purely on the basis of the fresh engagement order issued by the NCHSC, and there is no continuation in between. My lord, if I may pause here for a while, this is wrong, because, my lord, this honorable court passed the order, my lord, the setting aside the termination, but then, my lord, that will not come in the, my lord, way of deciding the issue. As per OM issued by Government of Assam in the Hills Area Development Department wide notification dated 25/5/1996, and Education Department Government of Assam notification number such and such dated 15 February 2005, the Department of Education has been brought under the administrative control of NCHSC. Thus, in the greater interest of the students on the Dima Hasao district, the engagement order has been issued purely on contractual basis. As such, it is to be stated that as per OM issued by the Education Department, Government of Assam, dated 15 February 2005, the Governor of Assam has entrusted the college education general and has delegated the functions relating to college education general to NC Hills Autonomous Council. However, no any specific SOP in this regard has been issued. With respect to the appointment, all the grade 3 and grade 4 staff under the NC Hill Autonomous Council, including the college, are done by the council authority, and at the same time, all the accepting and releasing of the staff and officers, including the college lecturers, are carried out with the approval of the council authority. My lord, my submission will be, my lord, this clinches the issue whether, my lord, NC Hills Autonomous Council is the appropriate authority to regularize the service also, my lord, because my prayer in the petition is for regulation of their services. So after that, my lord, it is only a direction that your lordship pursuant to this order, there has to be a direction to regularize their service. In fact, my lord, after serving for about 24 years, one is about to retire also, my lord. And the other grounds that we've taken in the, my lord, writ petition is that only these 3 persons have been left out. All other, my lord, contractual 3F employees have been regularized. Those orders, my lord, we have annexed. And, my lord, there are 2 affidavits already filed by the principal secretary of the, my lord, NC Hill Autonomous Council. There, my lord, the stand are 2, my lord. Firstly, NC Hill district makes appointment because of the fact that once they are appointed by the government in, my lord, Haflong, they get a transfer to, my lord, other part of the state, for instance, Cotton College. So, my lord, they resorted to 3F appointment. That is one. And my lord, in the additional affidavit that was filed on 23rd of November 2022, the same my lord principal secretary has taken the ground that NC Hills Autonomous Council has power to appoint. And this is, my lord, fortified by this communication that has been, my lord, put on record by the council for the, my lord, Autonomous Council. Therefore, my lord, the issue has been answered by them itself, my lord.
So if any regulation to be done, it can be done by only NCHL's council only, not by the others.
That is, my lord, I think that is clear from the, my lord, last paragraph of the communication. Dated 12th of February. May I read that again, my lord?
No, just a minute. Just please take your seat. Just want to look at something. What is the order of the court earlier?
That is
Because
my-
in this particular note, they have said that you have been re-engaged by the NC Hills on contractual basis.
My lord, even then, that does not come in the way of regularizing.
No,
sir.
definitely not. But what is that?
The order that was passed by the, my lord, honorable court in the earlier ratification that your lordship will find at page 46.
What is the order of termination? Order of termination is 42.
Page 38, my lord. Relevant page 40,
38 is the type copy.
my lord.
And the order of the court,
Order of this honorable court is at, my lord, page 46. No, I'm sorry, my lord.
It's not 46.
No, in fact, my lord, that order has been reflected here. Court's order has been reflected, that has not been annexed, my lord. Page 46, my lord, the authorities have, my lord, referred to the order. Service of those 3F employees have been terminated, they should be allowed to continue their services in the cases disclosed of by the Honorable Guwahati High Court. Those fresh lecturers who were appointed against the post of terminated 3F employees, they should be asked to wait to join in the final decision pronounced by the Honorable Guwahati High Court in the pending cases. Those 3F employees who were working continuously in your college and have been regularized by the government notification that is so and so, they should be allowed to continue their services, allowing them to submit a fresh joining report after regularization. So others are, my lord, regularized. Those teachers who were working either as 3F employee or regular lecturer but transferred out of Haflong Government College by government notification that is so and so, they should be released forthwith in order to enable them to join at their new place of posting. In fact, the principal secretary says this is the reason why, my lord, they have resorted to 3F appointment, because the persons get appointment in Haflong and Difu, then with influence, my lord, they come to Cotton College. No, order to the order, I mean, I told her.
No, that he করে দিছে yes withdraw করে দিছে একটু continue in further.
So, my lord, whether it is a fresh appointment after the High Court's order or, my lord, it's a continuation, that is not a relevant issue for deciding the list. If your lordship comes to, my lord, page,
who is for the NC Hills? Please come this way.
page 92 and 90, my lord, your lordship will find similarly situated persons.
There is an affidavit filed by the respondent number 2.
Rest of it.
It starts at page 105. It was filed on 5th of January 2022. Deepak Mojumdar. Do you have a copy?
Yes, my lord.
Do you have a copy?
No, lordship. I can give him my copy, my.
Now, in that particular affidavit filed on 5th of January 2022, the Secretary Government of Assam, the Higher Education Department. Kindly read para 40, para 12. Internal page 5. Kindly read.
The deponent begs to state that in view of common judgment and order dated 5/6/24 passed in WA.
Okay,
so-and-so,
already
so-and-so,
read it,
so-and-so,
please. Okay.
The service of petitioners along with other appointments under Regulation 3F of Assam Public Service Commission limitation and function, Regulation 1951, as a lecturer were terminated with immediate effect by letter dated 25/5/2004 and requested the principal Dipu Government College Dipu and the principal Haflong College Haflong to release the petitioners along with others. After that, petitioners were engaged by the NCL's Autonomous Council as lecturers on contractual basis.
What is your stand?
Lordship,
Correct. You
we
have
have-
re-engaged the petitioners on contractual basis.
yes, Lordship.
Where are those orders?
Orders we don't have, but we have stated in our affidavit, Lordship.
Your affidavit filed when? 23rd of March. Filed by whom?
Lordship, respondent number 3, Lordship.
Srimati Nampui.
Yes, Lordship.
Where you have stated?
In paragraph number 3, Lordship, that with regard to the statement made in paragraph 4 of the writ petition, deponent begs to state that the petitioners were appointed by the Deputy Secretary to the Government of Assam, Education Higher Department, Higher number so-and-so, dated Dispur so-and-so, for a period of 4 months as a lecturer under Regulations 3F of Assam Public Service Commission, LNF Regulation 1951. Lordship. Lordship, here we have to take the concurrence of the Finance Department and APSC also, Lordship. That was not given, Lordship.
In that particular affidavit, the respondent number 3 says that the regulation can be done only by the state government,
Yes, Lordship.
not by the NC Hill.
No, Lord.
But the state government have clarified it is the NC Hill.
But our affidavit is
Mr. Gogoi, what is the stand of the government? Because earlier that notification that you have placed, that the communication that you have placed before the court reflects that it is the NC Hill Autonomous
They
Council.
cannot lordship.
They cannot regulate.
They cannot lordship. Sixth schedule higher education is not a transferred subject lordship. Only general college education is transferred subject lordship. They cannot.
Government college is not a transfer subject.
They cannot lordship. They cannot. As per the 1982 rules lordship.
But this particular, on 12th February 2024, the communication was made.
We have to go by the rules and procedure prescribed by the statute lordship. And we go by the provisions prescribed by the constitutions lordship. Even lordship, that TF part is already decided by the honorable division bench of our High Court lordship. as well as full bench also, Lordship. And division bench, those persons who were appointed earlier in the 3F, Lordship, including Cotton College and other colleges, Lordship, they approached the Honorable Single Judge rejected their claim, then approached the division bench. A series of, Lordship, writ appeal was dismissed by the Honorable High Court, Lordship.
Pursuant to the same, they were terminated, right?
Lordship, on the, not only dismissed, the direction of the Honorable Court is that they should be terminated forthwith, Lordship. Even on the basis of the direction of the division bench, Lordship, that their service were discontinued, Lordship. And
Now,
after
thereafter-
that, the own risks of the councils, they have engaged, Lordship. The burden shift to council, Lordship, whether how can they can adjust or how they can give the salary, Lordship, it is on their own pocket, Lordship, not the pocket and exchequer of the, Lordship, state of Assam, Lordship. We cannot, Lordship. We cannot, Lordship, validate the illegal acts, Lordship, which cannot permitted under the statute, Lordship.
Now, that particular, which Mr. Chaudhary read as a communication of the principal secretary of the NC Hills Autonomous Council.
Lordship.
Do you have the copy?
I have not, otherwise also, Lordship, that just
Do you
my,
have the copy?
Lordship, I have not the copy,
Mr. Chaudhary, just give him. a copy.
Lordship.
Do you have that copy?
My lord, I have got only one copy. I'll, my lord.
Just give it for the, just reading.
Yes.
That communication of the NC Hill authorities.
February, Lordship, on 8th February 2024, Lordship.
12th February.
12th February.
Mr. Gogol, just read the last
Lordship,
para.
Lordship.
Last paragraph.
As such, it is stated, OM issued by the College Education General, Lordship. It is already I am submitted, Lordship.
Read.
General has been delegated the function leading the College Education General NC's Autonomous Council. However, no any specific SOP in regard has been issued with respect to the appointments of all Grade 3 and Grade 4 staff of the NC Autonomous Council. In the college are done by the council authority, and same time all the accepting and releasing of all staffs and officers, including the college lecturers, are carried out with the approval of the council authority, Lordship. It is for releasing, Lordship, releasing of the staff. Regarding appointment part of Grade 3 and Grade 4, it was done by the council, Lordship. And general education, there is no dispute, Lordship. It's a constitutional mandate, Lordship. General education is there, Lordship. General college education. Regarding Gate 3, Gate 4 post also, now, Lordship, is a centralized body was constituted by the government of Assam, Lordship. It is done under this, Lordship. Not only 6 schedule area, Lordship, whole of Assam, Lordship. Only percentage is different, Lordship. Now, Gate 3, Gate 4 also they cannot, Lordship. The board will constitute, Lordship, and as per the board, Lordship, the policies as given by the and reservations is for a particular area, Lordship, that part is 6 schedule, Lordship. And for a moment, my lord may kindly peruse page 13 of the repetition.
Just a minute. Page 13.
Page 13 of the repetition.
Yes.
My lord may kindly peruse the pair A, Lordship. What is the pair of the repetition, Lordship? A writ in the nature of mandamus should not be issued, directing the respondent to regularize the service of the petitioner as lecturers, assistant professor in physics, history, zoology subject in Haflong Government College. My lord may kindly mark it by relaxing the rules as has been done, Lordship, in case of similar situated, Lordship. Whether, Lordship, read court and the Lordship, authority can relax the statutory rules, Lordship, to accommodate the others person, Lordship. How, whether it can be permissible under the law, Lordship? We have to done is as per the statutory prescription prescribed by the statute, Lordship. It was from the day of Privy Council, it is reiterated In lastly, Lordship, in Mohendra Singh cases, Lordship. This reiterated time and again by the Honorable Apex Court, Lordship. We cannot, Lordship. The law laid down the golden principles of law, which was laid down by the Privy Council, Lordship, is still whole in the field, Lordship.
Yes,
My lord,
we'll come back to him. This particular file in your additional affidavit filed by the respondent number 3. On 23rd of November 2022. You have the affidavit,
Yes, Doctor.
the last page.
Page 106, Doctor.
106. Get this file day after tomorrow. Day after tomorrow.
Lordship, the instruction over this.
Get this file.
Oh,
Placed
day
on,
after, Lordship, day after tomorrow. is
day after tomorrow. You inform, they will come tomorrow. With the file. List on 11th, list on 12th. What's your good name?
C. Sharma. Lordship, next week, Lordship.
Sorry. Enabling standing council, not Kachari Autonomous Council of Long. To place the relevant record. Relating to file numbers. ZA/PS/3 dash college /2009-2010. Of the NCHAC, Dima Hassan District, NCHA Secretariat of Long, as well as in original, the records of NHA /HGC MISC /2013-14 of the Additional Director of Education Assam Haflong, relating to engagement of the petitioners as contractual teachers in Haflong Government College, Dimahasa, Haflong. One teacher is working in Haflong, the other one?
All of them are working, all of them are working in the same college, my lord.
Copy of this order. First, Mr. C. Sharma. Attorney first, portrait. Of the petitioner.
My lord, may I, my lord, take one? If your lordship kindly comes to page 92.
92.
My lord, page 92 is an order where similarly situated persons have been regularized by the, my lord, state government.
That was when?
1.2. My lord, page
That was
92.
When?
That is an order passed on 27th of February 2016.
Okay.
But that record also your lordship may like to see. Because, my lord, the stand of the government is that we cannot regularize, but they have done it. The stand that has been taken is that there cannot be a negative equality. My lord, what is negative equality? So it gives power to them to pick and choose. That is violative of Article 14. This is my specific case that there are
But
three.
on the date of the regulation, whether the candidate is required to have the required eligibility or not.
My lord, so far as the, my lord, the petitioners are concerned, my lord, 1 and 2, petitioner number 1 and 2 and 3, my lord, they have got the, my lord, eligibility. In fact, my lord, they were all recommended by the APSC earlier, but they did not come within the zone of consideration. Therefore, my lord, the prayer, my learned friend is showing, my lord.
The date of the regulation of the service, whether, see, we're talking about our service, in the High Court service.
My lord.
There are many grade 4s. When they enters, they are only classes. Subsequently, they becomes matriculate. Or some of them pass higher secondary. Now, for those who are in the matriculate, considering the length of their service, sometimes they used to apply for higher service because in the absence of someone, we always allow them to work in that particular. But even if we consider for regularization, we cannot consider him for regularization in the higher post because not having the required eligibility as specified by the date of the regularization. That's what we follow.
True.
Now that is where I'm asking you whether, if assuming that the petitioners are entitled for regularization, some directions are issued by the, whether the petitioners have the requisite eligibility or not for the regularization. They have it.
But then, my lord, what I try to improve your worship is that by seeing this record, your worship will know, my lord, how they were, my lord, were left out in others.
See, that was if something has been done, but that is not under challenge. Only you are giving a showing that it was done earlier.
Because I
If
see
it
that,
was
my
done
lord,
earlier-
I'm similarly circumstanced. That is
Lordship,
my
in
case.
this matter,
And
they
they said,
didn't
my
have
lord, the
the
government says that, my lord, there cannot be negative equality. That is the stand taken.
Mr. Gogoi, where is that rule, Assam government?
Lordship, 1982 rules.
1982 rules. In this book,
698, Lordship.
698.
Lordship. Assam Education Service Rules 1982, Lordship. And Lordship, regarding recruitment,
Assam
Lordship.
Education Service.
Lordship. 1982, Lordship. Method of recruitment is Lordship 702, Lordship.
Other persons have been regularized by virtue of a cabinet decision.
That we have seen, the first line itself.
And all they require to do is, my lord, take a cabinet decision, but the influential peoples have got that, my lord. The petitioners are not influential, so that didn't happen to them.
Mr. Gogoi,
Lordship.
711 page.
711, actually.
Rule 29.
Rule
29.
29, Lordship. Lordship.
That power is with the government.
Lordship.
Okay.
Hello, bless.
That power is there, Lordship.
With the government.
That power is, Lordship, in respect of eligibility and other things. Not for, Lordship, illegal appointment to be regularized, Lordship.
Let us see.
That power is not that, Lordship.
We'll see to that.
That is not the power, Lordship.
If that
That
is the-
relaxation power is, Lordship, already clarified. relaxation in respect of any hardship, in respect of the provision prescribed by the statute, then lordship relaxation should be done. But relaxation is not done for persons who are illegally appointed to be regularized, lordship. This is
Now-
not the purpose of the legislature, lordship.
Page 93, which been pointed out by Mr. Chaudhary.
Lordship.
And what are the procedures?
It's a by way of cabinet decision, whether honorable court can give a direction for
Is
cabinet
what we are-
decision, that honorable court will decide, lordship.
Definitely.
That part I will not do, lordship. Yes, because what is, whether Article 226
already-
permit lordships to give a direction to the state cabinet to take a decision, lordship.
Mr. Gogoi, you have already pointed out the page 12, the prayer
Lordship.
portion, right?
Lordship, lordship,
You are
lordship,
aware of that?
lordship, lordship, lordship.
Prayer portion,
Obliged.
he read half of it, my lord. He did
Obliged.
not read the entire one. Selective reading.
Otherwise, lordship, the issue is already settled by the division bench. Whether after settled by the division bench, whether honorable lordship may open this issue, lordship, that part also the lordship have to consider, lordship. Oblige, lordship.
Please, my lordship, may I pray an adjournment?
Lordship.
There was a mention in the morning, right?
Yes, sir.
Take your seats. Service. State government service. এই আসাম চাৰ্ভিচ মেনুত এই কলা কিতাপখন তলত এই ডাঙৰ কিতাপখনৰ তলত এখন নতুন এখন আছে। Where is Mr. Gogoi? You can also submit. There is a provision in the Assam government service. Without the approval of the government employee cannot apply for other posts. There is a provision in the service rule. Are you aware of that provision? Mr. Or is that provision? It is there in the Assam service rules. Ask Mr. Gogoi. Either Buddha Gogoi or K Gogoi, they will be able. Sixty, where is left? Yes, sir. See that, Mr. Gogoi, there is a provision earlier used to always place that, without obtaining government approval, they cannot go for higher education and.
In Lordship, as per our rules, Lordship, Rule 27.
2010 rules.
2010, Rule 27 or 20, I just. 24. 24. 2010 rules, okay, 10. My lord, 23 lordship, and no objection is 24 lordship. 23 is the lien deputation and study leave lordship. Lordship 503 page.
Yes. Mr. Fupan, you are representing whom?
But I'm for the petitioner, lordship.
You are for the petition. Who is representing the respondent number 8? Who is representing the KK Hendrick University? You are representing.
No, so
Lordship,
Lordship,
I'm this.
KK Hendrick.
Who is representing KK Hendrick? You are representing KK Hendrick.
Yes,
Okay, fine.
Lordship, my senior is not present.
Doesn't matter. You just have to read. You have the affidavit filed earlier on, copy of the affidavit. 1st March 2021. Yes, Mr. Fukan, give it. You read. You have the affidavit, 1st March, filed by Arup Jyoti Chaudhary.
Yes, Lordship.
You have? Okay. Now come to paragraph 6 of the affidavit. Kindly read.
That as regard the statement made in paragraph 4 of the writ petition, the answering deponent begs to state that the condition of for no objection certificate from the employer was only directory in nature and said conditions were not mandatory. That is, cannot be essential condition.
Mr. Fukan, take your seat.
In fact, the required qualification and requirement of the for the post of assistant professor were upheld in the website of the university in a such as no objection from employer cannot be considered as required qualification for any eligible candidate.
Read 7.
That as regard the statement made in paragraph 5 of the writ petition, the answering deponent begs to state that 7 candidates appear before the selection committee on so and so, out of which 3 candidates were shortlisted by the selection committee. The respondent number 8 was at first position with 74.4 mark, total mark 372 awarded by 5 experts. And the writ petitioner was at second position with 70.4 marks, total mark 352 awarded by 5 experts.
Read 8.
That as regard the statement made in paragraph 6 of the writ petition, the answering deponent begs to state that out of 10 candidate, only 7 candidate appeared before the selection committee for interview.
9.
That as regard the statement made in paragraph 7 of the writ petition, the answering deponent begged to state that on so and so, the respondent number 8 appeared before the selection committee and submitted a undertaking wherein the respondent number 8 mentioned that he is working as assistant professor in Assamese in Pragjyotish College since so and so, and he has variably informed the college authority about application for the post in question, and further he declared that on selection and appointment for the post in question at Krishnakanta Handicap State Open University, herein after referred as to KKHSOU, he will resign from the post of assistant professor in Pragjyotish College. It is mentioned herein that considering the undertaking given by the respondent number 8, the selection committee allowed the respondent number 8 to appear in the interview for the post of answers Assamese at KKHSOU.
10.
Yes, Lordship.
Para 10.
That as regard the statement made in paragraph 8 of the writ petition, the answering deponent beg to state that the condition for production of the no objection certificate in original from the earlier employer was not a mandatory qualification requirement for the post of assistant professor in KKHSU. In fact, while selecting candidate for the post in question, the selection committee focus on merit of the candidate as mandate by UGC regulation.
12.
That as regard the statement made in paragraph 10 and 11 of the writ petition, the answering deponent begged to state that since the no objection certificate is not a mandatory essential qualification for the post of assistant professor, the selection committee rightly allowed the respondent number 8 and Dr. Pallavika Sharma to appear in the interview process. It is mentioned herein that the selection and appointment for the post of assistant professor at university is governed University Grant Commission Act as well as rules formed thereunder. The UGC regulation on minimum qualification for appointment of teachers and other academic staff in university and college and measures for maintenance of standards of higher education 2018 is holding the field of for appointment of assistant professor at university, and such regulation 2018 do not insist upon any no objection certificate for employer. Therefore, the selection committee allowed candidate to appear in the interview without insisting upon no objection certificate.
Okay. Now please come back to paragraph 9 again.
Yes,
in the middle portion that you are aware that the AK Handling authorities are fully aware that the petitioner, the respondent number 8, I believe, has been working as an assistant professor in Assamese in Pragjotis College since 28th of February 2020, right?
Yes, Lordship.
Mr. Gogoi, give him that book. Now please come to page number 490.
Yes, Lordship.
You got it?
Yes, Lordship.
You got it? Now come to just read the act. What is the name of the act?
So, Assam College Employees Provincialization Act 2005.
Now please read the preamble down below.
Yes, Lordship. Whereas it is expedient to provincialize the service of employees of the non-government college in receipt of deficient grant in aid from the government of Assam.
Then read section 1, 2, and 3. Section 1, subsection 1, 2, and 3. Read that entire section.
Short title, extent, and commencement. This act may be called the Assam College Employees Provincialized Act 2005.
2.
It extends to the whole of Assam except the Autonomous Council area under the 6th schedule of the to the Constitution of India. Provided that the state government may in consultation with the said Autonomous Council extend this act to the Autonomous Council areas by notification published in the official gazettes.
3.
It shall be deemed to have come into force on and from the first day of December 2005.
So you have seen that the respondent number 8 started working in Pragjotis College, which is a provincialized college, and assistant professor in Assamese from 28th of February 2020. That means after provincialization. Yes. Provincialization Act has come into force of 1st of December 2005. Now please come to rule the Act section 12, page 495. 495.
Yes, Lordship. 10. Suits and proceedings.
No, section 12, 495. There is a section 12.
The power of the government to make rules. One except for the purpose of payment of pension, which will be governed by the Assam Service Pension Rules 1969.
So except for the pension rules, then read, which will be the government 1969, the state government.
The state government may by notification in the official gazette marks make rules for carrying out the purpose of this act.
So this particular section provides for framing of rules under the 2005 Act. Now please turn the page, come to page 496.
496, yes. Lordship.
What is the name?
As the Assam College Employees Provincialization Rule 2010.
Read the top in exercise. Read.
In
In
exercise of power conferred under subsection 1 of section 12 of the Assam College Employees Provincialization Act 2005. Assam Act number.
Okay, the governor.
The governor of Assam is hereby pleased to make the following rules for carrying out the purpose of the said act, namely the.
Okay. Now you have seen that this rule 2010 rules have been framed under section 12(1) of the 2005 Act, which you have just read, right? In the previous page, you have read section 12. Now come to page number 504.
Yes. Yes, Lord.
Read rule number 24.
No objection certificate for higher studies and applying for jobs. The governing body shall issue no objection certificate to the college employees for applying for admission to course of higher studies and for other jobs.
So as per this rule, for applying for the other jobs, there is a requirement of no objection certificate from the governing body of the college, right? And this rule has been framed under the section 2000 for the 2005 Act.
Yes.
So since this rule has been framed under a statutory act, this particular provision of Rule 24 has statutory force. No one can go bypassing that rule, can apply for any other jobs. Right?
Yes.
And in this case, the KK Hendick University admitted the fact that the petition response number 8 did not apply or did not provide any no objection certificate from the government, as it was not required in that university. But it may not be required in that university if somebody is working in that university and applies for job in other places. For them, it may not be required. But those who are serving in provincialized college, the Assam, under this 2005 Act and 2010 rules, he or she, if applies for any other job in other places, have to have the no objection certificate from the concerned governing body of the college, which indicates the response number 8 doesn't have.
Lordship, this has some more instruction we have to.
What instruction we do not know? Ask Mr. Fukun to be here at 2 o'clock.
Lordship,
Wherever he is.
He is not here, Lordship. He is not in Guwahati, Lordship. He is out of Guwahati, Lordship.
Out of Guwahati, tomorrow in that case.
Tomorrow. Much obliged.
Tell him. Now who is representing KK Hendick? Who is representing KK Hendick?
Yes, Lordship.
You are representing the respondent also.
No, I'm from.
You are from the you are representing respondent, Mr. Dekar. How will you bypass that rule 24? It's a statutory provision.
I resigned from the state.
Resign when? After getting the job?
No, before.
Before resign? Before resigning, when did you resign? Your application for that particular post will be
Sir, applying.
after applying. After applying, how can you apply? How can you apply?
I have applied for the NOC, but college didn't require me.
Then in case without the NOC, you cannot, that's the rule. So many judicial officers, so many high court employees are applying for LLB, LLM. Why they are applying? Before the high court, before the registry of the high court for giving consent. Why? You know the outcome now. You don't follow the rules, which is a provision of statutory force. Outcome will be set. Tomorrow.
Obliged, Lord.
Me plead your lordships. In this case, I am appearing on behalf of respondent number 7, madam.
You have corrected it. It was lying in the defective section.
Yes, my lord. I have filed it, corrected.
You are appearing for respondent number 7.
Yes, madam.
Your affidavit was in defective.
No, it is his,
Oh, no, read petition.
I have already filed, he filed
The reply of the.
reply of the my affidavit, madam.
Right.
I send a recorder. Defective হইতে গেলে হবে না, হইবো না? করবে না। করে দিয়ে আর কোম্পানি হবে
Your service has been provincialized under which act?
My lord, 2017 act, my lord. My service has not been provincialized, my lord.
Your service has not been provincialized.
Not been provincialized. My lord. Service of respondent number, my lord, 7. His service has been provincialized, my lord. Both are language teacher. Petitioner is Assamese and English, and my lord, respondent number 7 is Hindi. The petitioner is senior to the respondent number 7, my lord.
Do you have the act with you?
No, my lord.
Read section 14.
Section 14 is the appellate authority, my lord.
Read.
The state level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee. And the state government in concern, and the state government in the concerned administrative department shall be the appellate authority against any recommendation of the state level scrutiny committee.
Now, in the present case, who recommended? The district scrutiny committee recommended you or no?
My lord, they have filed an affidavit, my lord.
Whether the district scrutiny committee recommended you or no?
My lord, as per their government, in the affidavit, my name has not been recommended.
So you are agreed by the recommendation made by the district scrutiny committee?
No, my lord, that, my lord, because the act, my lord, does not prescribe any procedure, my lord, for intimation of the recommendation, my lord. Now,
see, basically, it is always in the website, right?
My lord.
After, there are two processes. Once the district scrutiny committee recommends,
my lord,
it is uploaded by the concerned directorate
my
on the
lord,
website.
my lord.
But these are the teachers who have been considered for provincialization.
That have not been uploaded, my lord.
Everything has to be uploaded. Cannot be, there cannot be a bypass of that. There has
there,
to be.
my lord.
That means you are not aware that it was uploaded or not.
No, my lord, because that
Cannot be.
that hasn't uploaded. Because, my lord, so far the process of provincialization.
Yes. Tell us. It was not uploaded.
Recommendation, my lord. SLC has uploaded.
Before recommendation.
No one, no uploaded.
It was not uploaded.
No.
What was the procedure?
Well, the procedure is that my DLC forwarded the name of the concerned persons to the SLC. my lord.
When do you upload?
After recommendation by the SLC. my lord.
After recommendation of the.
My lord, who are eligible for appointment as a teacher.
That list also not been, my lord. Only the after provincialization, my lord, they have uploaded the name of the, my lord, person.
He has the knowledge, but his name has not been forwarded by the DLC. my lord. He should have
another fact.
island.
Even if it is uploaded by the state level committee, there is a provision for appeal provisions.
True, my lord. He has not approached it, my lord.
No. My lord, may I submit, my lord?
There are several judgments passed by this honorable court lordship also, my lord.
They
Directing the petitioner to approach the, my lord, appellate authority. my lord. Recommendation is something different. And my lord, with all due respect, my lord. After recommendation, my lord, the person. All due respect, my lord, engage my lord, teacher. the procedure, what they are following is that, my lord, that the DLC, my lord, only recommended, my lord, the name of, my lord, those three teachers whose name has been, my lord, recommended. My lord, that is true, my lord. My lord, attaching, my lord, by, my lord, fact, my lord, by way of, by way of, my lord, scanning. The minutes, my lord, subsequently they kept with them, the, my lord, DLC step. So how can the SLC will determine, my lord, whether the not recommended, those teachers' name, whose name has not been recommended unless and until it is sent by the DHC to the SLC. Only three teachers whose my lord, found, my lord, they, at their own whims. That is the procedure, my lord, going on. And I'm agreed by the appointment. Well, that is the, my lord, expectation, outcome of the non-recommendation recommendations and non-recommendation, this is prior appointment, my lord. I'm here challenging the appointment order of the private respondent. He has filed a complaint before the, my lord, CM Vigilance, my lord. According to his complaint, my lord, a inquiry was made by the deputy commissioner. There is a public petition, well, that is not in, my lord, individually. That some anomalies, my lord, irregularities going on in the entire Jorhat districts. Well, considering that aspect, well, there is a public petition, not in individual, but they are, my lord, individually only submitting the report against me. 226 is amenable, mal. How can they reduce the code for an actually? They are only interested to, mal, appear before their officers who has committed the error, not by the owner.
Where is SSA?
My lord. Earlier occasion, my lord, the SSA has been directed to get the, my lord, title of 2009 and all.
Right.
My lord, heard Mr. B.K. Das, Learned Counsel appearing for the petitioner. Who is appearing? You are appearing?
Limited. My lord, may I just make one humble submission? My lord, I have, my lord, submit, my lord, file an additional affidavit. My lord, that, my lord, to substantiate that, my lord, after 2000, my lord, 2015, the petitioner is available in the record. In the school, my lord. And this may be, my lord, additional affidavit, that you can see number page 64.
Sorry, underscore. Learned. Pending council. Elementary education for the respondent number 1, 2, 3, 4, 5. No, 1, 2, 4, 5. Mr. DP from Advocate Assam. For the respondent number 3. Appearing for 6 or 7.
And only 6.
Who is for 7?
Hiroda Bora. 7, 7. Sorry. 7, only 7.
Nobody is appearing for 6.
Then I have no idea.
Chief headmaster nobody.
Anybody is appearing for 6?
Then I retired it.
Next.
He has already.
He has already been retired.
So prior provincial election, 2020, prior provincial election, she has retired. She has attained the age of superannuation.
6.
6 months. Even though her service has been provincialized.
He or she, you're talking about he or she.
He, He. He, number. May I just,
Just a
H. Purva. On behalf of B. Chaudhuri, my lord.
Okay, that's one number. Contention of the petitioner is that since January 1994, he is serving at Jadavpur Sahapakisa Upper Primary School. In the Central Jorhat Education Block since its cancer stage. And was teaching subject of English. They say to cancer school. He is aggrieved as the state respondent while considering restrictions for provincialization in the services of the teaching and non-teaching staff of say Jadavpur Sahapakisa Upper Primary School. Disregarding his seniority and better claim by orders What is the appointment at the order, success tutor?
05.
Their appointment as tutor.
05/02/2021.
Where are those appointment orders? Yes, Ms. Devi, where is your appointment order?
Before provincial election.
Not up, as your appointment as tutors.
One to
54.
Yes, Mr. Das, in which page you have annexed?
My lord,
Their
that is,
appointment order.
that is in my affidavit, my lord.
Kindly tell us the page number.
Which is my lord. But my affidavit on page number 78, my lord. Serial page number 78. Of my affidavit in opposition.
Pune.
What people got it?
The repetition lordship, can you believe?
Appointed the respondent number 6.
Niroda Bora. Respondent number 7.
As respondent number 6 and 7 as tutors. It is also submitted by the petitioner. That the respondent number 6, prior to his appointment as tutor, I have already retired from service on attaining the age of superannuation. And that the respondent number 7 joined as a tutor in the base school 415 number Sotai Bosti, SOTAI, Bosti BOSTI, Bonua, BONUA, Lower Primary School. Pursuant to the order of the state government in the Elementary Education Department, wide number EPD -16 oblique PROV and B capital UP capital within bracket Act 2017 bracket close oblique 202 oblique 3583. And as per the provisions of the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act 2017. The consequential order issued by the Director of Elementary Education Assam, wide number EPD -16 oblique provincialization of PROVN P capital UP within bracket Act 20217 bracket close of 2021 oblique 3583 bracket 0502 2021. Rule 3 in bracket Roman 11 of the said 2017 Act provides that in case of Spencer Upper Primary School, there shall be minimum 3 teachers or 3 posts, at least 1 teacher each for within bracket small a science and mathematics, comma small b bracket of social study and the small c within bracket languages, provided that for additional posts it shall be considered in accordance with the norms and standards stipulated in the schedule under sections 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009. The Director of Elementary Education Assam, respond number 2. Filed a detailed affidavit in the matter. Stating that the petitioner filed a complaint petition before the Minister's Vigilance, right? Regarding non-consideration of his case for provincialization.
Not his case, my lord. It is
For
the,
consideration of the provincialization of the service of the respond number 6 and 7.
no, my lord. That is not in respect of 6 and 7. My lord, that is, my lord, in respect of the entire, my lord, the process of provincialization.
Provincialization in on extraneous consideration
Jorhat district, my lord.
in the district of Jorhat. Pursuant to the same, a detailed inquiry was made to the District Elementary Education Officer Jorhat. Wherein it was found that the petitioner remained absent in the school for a very long period.
Actually, may I just, my lord.
Come back to you. This is an affidavit of the respond number 2. And he did not attend the school since 2015. And that his name was at serial number 5 in the list submitted by the school managing committee for provincialization of services of teachers serving in the said staff officers school variety. After getting the said report from the District Elementary Education Officer Jorhat, the Director Elementary Education Assam on 27/06/2022, file number EPD/3/2022/78, issued an order stating that the allegations laid by the petitioner regarding recommendation of teachers against upper primary schools for provincialization of services as per 2017 Act under Jorhat district is not justified. As it doesn't hold any ground as there was no substantial proof in that regard. Further, I am communicating the said order to the petition. Further, the Deputy Commissioner Jorhat on the basis of a report of the additional deputy commissioner in charge of education in the Jorhat district, comma, its communication dated 08/06/2022, also inform the Secretary Government of Assam in the Elementary Education Department that there was no evidence regarding allegation of taking bribe was found as been alleged by the petitioner, and that the petitioner slash complainant did not mention about the said matter in his statement recorded before the inquiry officer. Moreover, as per the report of the president of the school managing committee as well as the in-charge headmaster of Jadavpur State ME School, the petitioner slash complainant was found of being absent from his duty since last several years, and then his name figured at serial number 5 in the list as per format submitted by the school managing committee for provincialization of service. The Director of the Elementary Education Assam, in its affidavit, submitted as per the requirement of 2017 Act. The District Scrutiny Committee after verification recommended the name of the respondent number 6 and 7 for provincialization of their service as stated under the said 2017. And the said proposal of the District Scrutiny Committee Jorhat was forwarded by the DEO Jorhat for provincial service against Jadavpur Tea Garden Arrangement based on enrollment position of the school during the year 2016. And that the name of the petitioner figured in the non-recommended list against the said ME school. The proposal of the DO Jorhat has been recommended by the District Scrutiny Committee Jorhat relating to respondent number 6 and 7 for provincial of their service was accordingly placed before the state level committee, and on being recommended by the SLSC, the respondent number 6 and 7 service was provincialized as tutors under the 2017 Act. Thereafter, the said recommendation of the SLSC was placed before the government in the year 2019, and on constitution of a joint committee by the government in its education department under the chairmanship of R.C. Jain IS retired from Chairman Seva. The said proposal was placed before the constituted joint committee to examine the proposal for provincialization of services. After verification of records and documents of the school and the teachers under the provision of 2017, the SLSC as well as Joint Committee's recommendation in the response number 6 and 7, service was provincialized as tutors under the 2017 against Jadavpur Tea Garden ME School. Only thereafter, the DE Assam provisional the services services of response number 6 by notification dated 05/02/21 as tutors. Since the District Scrutiny Committee Jorhat did not recommend, it is further step-free. Since the District Scrutiny Committee Jorhat did not recommend the name of the petitioner for provincialization, has been submitted by the DEO Jorhat. Therefore, the state level scrutiny committee as well as the joint committee could not recommend the name of the petitioner for provincial level services as per the authority. The DE Assam in its affidavit specifically stated that the district's community committee Jorhat recommended the name of the respondent number 7, the Hindi teacher of Jadavpur ME School, Jadavpur State ME School, the Tea Garden School, as the English teacher in the Assamese medium school of the district. Rule 14. Sorry. Of the said 2017 Act provides for form of an appellate authority, stipulating that the
My lord,
state level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee and the state government in the concerned administrative department shall be the appellate authority against any recommendation of the state level committee. In the case in hand, it is seen that while provincializing the service of one language teacher and one social service teacher relating to say Jadavpur Tea Garden ME School, The post of science teacher. Skip button. Further, the respondent number 6 was appointed as a tutor from the Dadapur Tea Garden ME School. Retired from service prior to issuance of the provincialization order as tutor. As his date of birth as per the UDICE of 2016-17 was 31st of December 1960, 31/12/1960. The read court is not a proper court to record the evidence, look after each and every document in evidence, to verify as to whether the petitioner remain absent from 2015 in the said Dadapur Sabaki Sahib Upper Primary School, or he joined in service in the said school in its Spencer States on 1/1/94, or that he was serving as a language teacher in that school. This can be considered only by a fact-finding authority. Considering the above, for the reasons above, and after hearing the party, this writ petition is disposed of with the observation that the petitioner may approach the uh, may approach the authorities in the state level scrutiny committee for redressal of his grievances has been provided under section 14 of the 2017. Since The Director of Elementary Education Assam, in its affidavit, clearly stated that the District Scrutiny Committee Jorhat did not recommend the name of the petitioner for provincialization of this. In the event of such approach by the petitioner before the authority concerned, the state level scrutiny committee has been provided under said 2007. The said authority in the event of approach the petitioner stating all his grievances. The said authority within a period of 6 months from date of receipt of such appeal / representation from the petition along with the certificate shall consider the same on perusal of the relevant records, including the attendance register, initial appointment of, including the initial appointment of the petitioner as the service the respondent number 6, 7, comma, the attendance register, the records of UDICE relating to the same records relative, the UDICE relating to the same school prior to the recommendation of the district scrutiny committee. And thereafter shall pass an appropriate order on proper pending of the case, giving an opportunity after, if so required, giving an opportunity of hearing to the petitioner as well as the respondent number 6. Further, the authorities in the state level scrutiny committee may also, shall also hear the DEO, District Elementary Education Officer Jorhat, and they verify the records in original that was considered by the district scrutiny committee Jorhat while recommending the names of respondent number 6 and 7 for provincial for the state school fund. If the authority concerned in the state level scrutiny committee after such verification comes to the conclusion that disregarding the seniority of the petition, the respondent number 7 was considered as a language teacher. The authorities concerned shall be done in full in accordance with. The petitioner shall submit such appeals / representation along with the certificate copy of its order before the director, right?
No,
District
no,
level, state level scrutiny committee is headed by the director.
Well, the Secretary of School Education.
That is the government.
Then I will have to prefer this appeal before the government, madam.
You have to prefer this because it is the district scrutiny committee who did not recommend your name.
The Director also upheld the illegal recommendation, madam.
Director is a different issue. As per the act, you have to go through, Mr. Tan. The Director of Elementary Education Assam, being the chairman of the state level Scrutiny Committee. As per the requirement of section 14 of the Act 2017. On or before. Twenty-seven, 09, 2024. Obtaining necessary acknowledgement from the said authority in that regard. They have observation.
Madam, till then, madam, the interim shall be continued.
Shall be
Just a-
executed, madam.
just a- No, the till such decision of the authority concerned in the state level scrutiny committee. The service of the respondent number 7 appointed as tutor by the order it is such and such in the said school attached to the such and such base school shall not be disturbed, and our provincialization as tutor shall be subject to the outcome of the appeal to be preferred by the petition.
No, my lord, already the interim is there, my lord, he's.
The interim order,
Till today,
No, my lord.
respondent did not get salaries, madam.
the interim order,
Lordship kindly pass an order.
The
to
interim shall
release
be
the
continued, my lord, till the, my lord, 27. And your lordship may give an observation if the petitioner will.
Mr. Das, have you been recommended by the district scrutiny committee?
Yeah, is it
No, my lord, because.
Have you been?
No, my lord.
Then keep quiet.
No, my lord, I am only praying that.
Lekha. Don't interfere when dictating the order. The interim order passed early on 23/07/2021. According to stands.
My lord, that will, my lord, give some bad impact, my lord. Because. My lord, can be, my lord, one observation that.
Go to the order, you'll know.
No, that will, my lord, with the interim order was possible, that is some
The-
arbitrary action was there.
The interrogation, this interrogation in view of the order passed to the
In
indication.
my lord, earlier occasion.
Application number 3157 is due to the being in first. Yes.
My lord, may I just, my lord, submit one thing, my lord?
Being in first stands.
My lord, just, may I, my lord, submit one thing, my lord, very briefly. My lord, if lordship will vacate the interim order, then my lord, the outcome of the appeal, that will be, my lord, that will be, my lord, meaningless. Because they will, if your lordship will vacate the interim order, they will release the order, my lord, they will release the salary. Thereafter, my lord, they will for indefinite period, my lord, they will keep the, my lord,
You have
appeal.
given the time limit for disposal of your appeal.
My lord, time limit given, lordship may kindly give an observation.
Yesterday, Your Lordship, matter pertains to Arunachal. Yes. Yes, Lordship, the few minutes back, Your Lordship, it is allowed to be filed here, Your Lordship. Therefore, Your Lordship, on 12, you will have to surrender, Your Lordship. Therefore, I am praying for listing tomorrow, Your Lordship. Okay. Lordship, deeply obliged.
File or yet to be filed?
I have filed, Your Lordship. Filing number I have received, Your Lordship.
You have give your filing number.
Yes, I have. Deeply obliged, Your Lord.
Yes, Mr. Bora.
My lord, already the process has been started. He has been asked to, yes, my lord. Appear before the principal and the interview.
Day after tomorrow, tell us, on Friday. Okay,
By today, he will be admitted, my lord.
on the prayer of the council for the petition, place this matter again on Friday.
Obliged, my lord.
Oh. May your lordship.
Itu report motion.
Your lordship, the petitioner put to challenge the provincialization order of the response number 7. Although he admitted in the earlier round of litigation, as well as the wrong committed by the district scrutiny committee, on the wrong foundation, lordship, his service is provincialized. So that is why I put to challenge the provincialization order of response number 7. All along, although a file affidavit and also admitted that he is a teacher of science, but the recommendation is made for language teacher. Although I am the senior most and the language teacher, my name is incorporated in the non-recommendation list, not eligible. Lordship, may kindly have page 29. This is the order by which the DO has approved the appointments resolution, lordship, where it clearly reflects the qualification of the teaching staff at that relevant point of time. The respondent number 7's qualification is BSc, and so far the petitioner is concerned, he is PO Arts. There is no any dispute that I am the senior most and teaching language. But in spite of court's direction as well as his own admission, the district scrutiny committee, lordship, recommended his name. That recommendation, lordship, find at page 33, annexure 6. Relevant portion at page 34. Details of tutor eligible for provincialization. Serial number 1, he is the response number 7 here. If you lordship kindly come to the subject taught English, it is apparently wrong. And so far the petitioner is concerned, his name is in the column number 7, serial number 1. So prior to this, lordship, we approached this honorable court, and this when the matter was finally disposed of, lordship may kindly come to page 49. This is the honorable court's earlier order, where he himself admitted, page 49. From third paragraph. Respondent number 9 is a science and mathematics teacher, who is the third teacher of that school, and submits that the statements made in ISO and so the position has been clarified. The clarification is regarding the subject taught. Yes, he admitted I am teaching science. So that is why this order is passed. Not coming to having no grievance as regards the annexure D. That annexure D, Lordship will find at page 40 and 41. This is the teaching staff pattern submitted by the respondent number 7 himself.
Page.
Annexure 10, page 40.
Annexure D.
Annexure D. Annexure D is the lordship. Page 41. Yes, this is the list. Lordship may kindly come to page 41. This was the list of Annexure D in IA. 6th of March 2020. page 41. Details of teacher's position of the science school. The petitioner, he was at that 11 point of time is headmaster. This was submitted by himself on 6th of May after filing the writ petition. Now, Lordship, kindly come to see the educational qualification and name of subject taught, maths and science. So accordingly, taking note of this admission, this order was passed. That page 50. Accordingly, joint prayer has been made by the learned counsel for the petitioner as well as the learned counsel for the respondent number 9. As the name of both petitioner and respondent 9 appears in the list of details of teachers submitted by the respondent number 7. At that time also he was respondent number 7. Headmaster comes secretary of science school. There is no dispute between the petitioner and the respondent number 9. Now dispute is regarding the subject taught. Now let's kindly come to that next paragraph. Having no grievance as regards annexure D, that is the list forwarded by the respondent number 7, which is the details of teacher's position in science school as submitted by headmaster on 5/3/2020, there would be no bar to the authority to do the needful for provincialization of state school and service of dear under. Now, this order was issued on 6th of November 2020. So immediately I submitted this order of the Honorable Court on 20th January 2021. And during pendency of my application, the provincial election order issued on 4th of February 2021. And that is why the petitioner is before your lordship. So on 5th of February, the provincial election issued, that is annexure 15, page 58. So apparently an illegal order. Lordship. In my service position, the service of the respondent number 7 is provincialized. And so far, although the respondent number 8 is also implemented as a party respondent, but he is a performer, he already retired. I have no grievance against him. He is the Arabic teacher. And my concern is only with respect to the respondent number 7. His provincialization order at page 58 and annexure 15. So that is why on last occasion, after hearing the parties, this honorable court given them a last chance to file affidavit, either file affidavit or record as to why they have not corrected and wrongly provincialized the service of respondent number 7. Now, if we go by the affidavit filed by the respondent number 7, he himself admitted, yes, I'm teaching science teacher.
Yes, Mr. Khatami.
My lord, here I have only limited instruction that my lord DLC has not recommended his name, my lord, for provincial election. My lord.
Issue was not recommendation. Issue is the wrong committed by the district scrutiny committee as well as both the committee. The document itself shows the recommendation of district scrutiny committee, page 34. English. But his claim is as a science teacher. But the district scrutiny committee at their own will or
Which date it was recommended?
Lordship.
On
Lordship,
which
this
date it was
date,
recommended?
so this was expect that is not given, but in 2020 itself. The date they have not given. Well, because immediately thereafter I approached this court. And that was why this honorable court disposed of by 6th of 11/2020. The mistake is apparent on this page 34. And this is continuing before the state level scrutiny committee also.
Mr. Khatami.
In fact, Lordship, that order was within the knowledge of the authority also, because on 22nd, They received it. The GC scrutiny committee received it 22nd January 2021. In spite of their knowledge, lordship, they have recommended and uploaded the name on 4th of February. Consequential order issued on 5th of February. So therefore, I again before this honorable court. In fact, lordship, page 17, annexure 60. From the authority concerned to the petition respond number 7, he was asked to clarify lordship. If you lordship kindly come to page 60, annexure 17.
Mr. Khatuna, this is the interrogatory application for vacating the stay that was passed earlier, and it was filed by the respondent number 7.
No.
This was in respondent number 7 file that the original I copy. Now, first of all, you read para 7 and 8.
That the applicant basis said that the read petitioner was appointed as second assistant teacher on 13/1/1987 in the madrasa and not appointed as language teacher as claimed by the read petitioner. The applicant states that section 3, 9, 10, 11 of the Act 2017 provides that minimum 3 teachers, tutors, upper primary school shall be provincialized, and as such, the read petitioner has got apprehension that his service may be dropped while provincializing the service of the staff. The applicant stated that read petitioners was under the impression that though his name was forwarded to the district scrutiny committee, but due to the restriction of the provincialization of service of more than 3 teachers of the upper primary school, district scrutiny committee may drop the name of the read petitioner from the staff of the school. And as such, the read petitioner requested the applicant to submit a representation before the district elementary education officer. Though the district elementary Bongaigaon for inclusion the name of the staff of the madrasa, and thus the applicant submitted representation on 24/2/2021.
Then come to page number 21.
Detail of the teacher's position of burden.
Who is teaching what?
My lord.
Who is teaching what, the seat?
My lord, here, my lord, petitioner, assistant teacher. My lord, he is teaching English and Assamese, my lord. Petitioner, respondent number 1, my lord, he is teaching maths and science.
So
this. Here, my lord, 4 teacher has been accommodated, my lord, one.
we are not on that.
My lord.
We have seen the respondent number
1 is teaching, my lord.
Respondent number 7.
7, my lord.
He
One
is supposed to be what kind of a teacher?
The math science, my lord.
He should have been
Math
considered
science.
as
Maths and science.
maths and science teacher. Then the respondent number 8.
Arabic teacher.
Arabic.
Arabic teacher. And the petitioner should have been considered as what?
Language. My lord. Assamese and English, my lord.
Arabic is also language.
Now, one Tahirul Islam has been considered as maths and science teacher.
Yes. My lord.
Wait,
And he is junior also.
why he has been considered? But you have not made him a party, Mr. Dekar.
Tahirul Islam. Since my concern is with the language. So that is why this 7 and 8 has been incorporated. But in the meantime, during pendency, 8 retired. 8 retired.
Now come to the last page, notice. Notice serve on the education department. Today's
Right.
training council.
My lord. Let us file our affidavit explaining the.
Now please come to page number 39. On the read petition.
My lord.
Kindly read.
To the Director, Elementary Education, Assam, my lord, proposal for inclusion, the name of the eligibility staff, Borzana and Shorter Memorial Girls and Madrasa for Provincial Services as eligible tutor. Application dated 24/2/2020 submitted by the Helpsman Borzana Shorter Memorial Girls and which refers to the subject stated. I have the honor like to inform you that at the time of the documents verification, the recognition of ME school proposed for provincial and non-government institutions and headmaster of the Borzana and Sotor Memorial Girls ME Madrasa submitted their teaching staff for provincialization of their services as eligible tutor for provincial and non-government institution Act 2017. In this connection, the subject-wise original teaching staff names submitted by the headmaster of the Borzana Sotor Memorial School Madrasa for provincialization of their services as eligible tutor as shown below. Foroz Ali Ahmed, headmaster, date of joining 5/1/1997, maths science. Here, my lord, serial number 3, petitioner Mubarak Hussain, Mokbul Hussain, assistant teacher, date of joining 13/1/1987, Assamese English. That is the correction original.
Now please come to page number 38.
Here also, my lord,
Fazir Ali Ahmed, qualification.
BSc, my lord.
When did he join service?
He joined on 5/1/1997.
Then the next teacher.
Next teacher, my lord, assistant teacher, SS, 11/1/1987.
He is serving as first teaching,
Assamese social science, man.
Then the petitioner.
Petitioner.
When did he join?
Join on 13/1/87.
UST
English and Assamese, man.
Then the next person.
Next person, my lord, join on 17/7/2006, maths and science, man.
When did he join?
17/7/2006, man.
Now the fourth one.
Abdul
last
Karim-
one.
Abdul Karim, 27/12/1987, Arabic.
Now the district scrutiny committee.
My lord.
Why change the structure?
That is the case.
Problem created before inducted Abdul Qadir Lordship, he is junior to petitioner. And he is also language. And the understanding between the petitioner and respondent number 8.
No.
As per my information.
Don't go beyond whatever you made in affidavit.
You own it.
Don't go beyond that. You'll be in trouble.
Court's order is there.
I'm withdrawing that word.
Is it there mentioned in the affidavit?
No, Lordship.
Then
That's why I'm
don't
withdrawing.
go beyond the affidavit. You have the act, Mr. Khatania? You have the act. Page 122.
My lord.
Section 13, subsection 11. Kindly read.
The state level scrutiny committee shall have to pause physical verification of all institutions and will also inspect all documents and records produced before it and call for such other records and documents as may be required for the purpose of pausing verification.
Read 12.
When there arise differences in between the recommendation of the district scrutiny committee and the physical verification report caused by the state level scrutiny committee, the matter shall be placed before the state level scrutiny committee and decision of the state level committee shall be final.
So apparently, the stand of the Director of Elementary Education Assam,
My lord.
the chairman of the state level scrutiny committee,
My lord.
right?
My.
Is that did not comply with the provision of subsection 11 and 12 of section 13. Whatever has been forwarded by the district scrutiny committee and been recommended by the district elementary education officer placed before the SLSC, accept the same, placed before the government, look after by the joint committee, approved. So what is the provision? What is the requirement of subsection 11 of section 13?
Have to
In the
verify
Act?
physical verification and verify all.
Forget the verification, whatever the documents
Other
verification.
documents required to verify.
So
regarding
in the previous case from the Jorhat, same thing has been
My
done.
lord.
Subsection 11 of section 13 was not complied with. Apparently made an affidavit, has been recommended by the district scrutiny committee, forwarded by the DEO, placed before the SLSC, accepted the same and SLSC placed it before the government and thereafter the joint committee. Is this? These anomalies would not have been there at all.
The verification is there.
What kind of verification? If that verification would have been there, the letter of the DEO is there.
In some
Why
cases,
this,
my lord,
why the person who is much junior to the petitioner has been considered? Why not the headmaster of the school has been considered as a science teacher? Why the petitioner has been considered as a language teacher?
Respondent number 7 is the headmaster.
Now just tell us, looking at section 3, Roman 11. It says the additional teacher
My lord.
on the basis of the enrollment.
My lord.
Now it's an ME school,
My lord.
right?
My lord.
Why only additional teacher in language in Arabic? Why not in science subject and the language, why in the social science? Why only considered for the fourth teacher? There has to be additional teacher for what? Additional teacher for every subject. All these three.
Probably
If
on
the
the basis.
requirements as per the enrollment is for additional teachers, whether the act says additional teachers is only for the language, if the number of students are more in language. It's an ME school. It's not a higher secondary school. So why you have considered the Arabic? You should have
Number-
considered for another science and maths teacher. You should have considered for another social science teacher.
There may be number of Arabic students.
You have considered it on the basis of enrollment. Then why you have considered only one person? Why not for the science and maths and why not for the social science?
My lord, let us produce the
What let us?
record.
Nothing doing. It's a matter of 2022. Total failure on the part of the SLSC in complying with the provision of subsection 11 and 12 of section 13.
I will place the record, my lord.
What will you place the record? How will you place the record? Already director has been chairman of the SLSC. See, difficulty is, depriving someone from the other side getting their salary, whatever maybe it is a tutor. Government, who is representing government? Where is government?
Duty.
Yeah, respondent number 7, Lordship, all along headmaster, and as per provision, RT Act 19 and 25, is service considered as headmaster, or against district scrutiny written English, but he all along teaching the maths and science, but he is a headmaster. Still he is a headmaster.
Mr. Barmiya,
Lordship, as part
is
of
there any provision in the act that the headmaster should be considered for provincialization and living, excluding himself, there are three more teachers has to be considered. Is there any provision?
Lordship,
Provision is only
RT
three.
Act, Lordship, headmaster, if the enrollment is more than 100, then headmaster, full-time headmaster is required.
Your
Petitioners all
school
along
has not been
submitted.
provincialized.
Yeah,
Your school has not been provincialized. Service of these four particular teachers has been provincialized as tutors and has been amalgamated in different schools, right?
initially amalgamated, but subsequently returned back all the teachers, serving the same school there. As per notification, subsequently notification issued by the commissioner.
Welcome to Sini. Huh? So what are you going to do? What year ready? So he could go.
And response number 8 is junior to the petitioner. Considered a language of.
So tell us what to do. Shall we call the deputy commissioner, director, everyone here? Or what do you want?
Well, I want to file a affidavit.
No affidavit. Already sufficient time has been given. We have seen the paragraphs form. It is already enough.
Let us produce the record, madam.
Whose record?
DLC, madam.
Will you be able to produce it by day after tomorrow?
No, my lord, may not be possible, my lord, from Bongaigaon, my lord. My respectful submission is that
See, the order of the court from the IA that you have just read. It's very clear. When there is a statutory order, right? The judicious order has been passed. Bypassing that, how can you continue?
That is well, so my respectful submission, even they produce the entire record, it will cannot alter this position. Because based on this report, they have provincialized. Suppose tomorrow they produce the record, it will not change the position. So that is why Lordship may give a mandamus, interfere with this provincialization order. It is bad, apparently bad. So set aside, Lordship. Let us take an example, Lordship.
Mr. Prigo. Ask him to be here. In the previous case, that from Jorhat, we have considered one aspect that in spite of the filing an affidavit and bringing it to the notice of the petitioner, way back in 2022, that the district scrutiny committee did not recommend the name of the petitioner. We directed to file an affidavit, an appeal before the authority council. Similar is the case here. But what we have found that the district scrutiny committee, Bongaigaon, headed by the deputy commissioner, did not comply with the provision of section 13, subsection 11 of the 2017. Because it is the duty of this, not subsection 10, because it is the duty of the district scrutiny committee to verify. The records were placed before the district scrutiny committee by the school authority, showing that the respondent number 7 is the headmaster of the school, who is a science teacher. His BSc degree holder. And then the school authority do place everything. But a junior teacher who joined service only in the year 2006 or something, I believe. Yes, July 2006 was considered as a maths and science teacher. Whereas the headmaster who is a BSc and was teaching maths and science, he was made a language teacher, thereby depriving the petitioner. So the district scrutiny committee headed by the deputy commissioner Bongaigaon did not look into all these aspects. And simply, so if you ask him for personal appearance and to so call, what will happen? In
Lordship,
the case of Jorhat, there was an allegation, right? That for the extraneous consideration, it was considered. However, on the basis of the report of the DU Jorhat and the Deputy Commissioner, because one ADC in charge of the education was directed to inquire and DC has submitted the report. That's a different issue altogether. But here is a case what we have seen apparent. We have asked Mr. Khatuniya, the stand of the chairman of the state level scrutiny committee is that it's headed by the director of elementary education. Headed by that, since the district scrutiny committee have it forwarded by the DEO. That is why the state level scrutiny committee did not consider it and place the matter, approve it and place the matter before the government. But that's not the provision as per the section 13, subsection 11. It is the state level scrutiny committee is required to inquire into the matter. Visit the school, verify the records, documents. It's not like a rubber stamp, whatever the district scrutiny committee will forward and it will accept. DEO has no power. Because DEO being the one of the member secretary of the district scrutiny. So. Is there any stay order in force?
no, there is no such say order. Understanding of the matter will be disposed of at the motion stage, then that is why on many occasions they are directed to obtain instruction on this recommendation. And as well as the court's order, why they have not complied this order? It is not their case that they have not received it. They have acknowledged it. Mr. Tipurna. And since 2020 is before this court launch. And he illegally getting the benefit, enjoying the salary lordship. That's one number 7. Lordship may interfere with this provincialization order as by in terms of the earlier court's order, leaving aside the affidavit or all other submissions. His own submission. And that is why that case was disposed of. Since both the parties were agreed. If Lordship, once I can come to the earlier order, Lordship may kindly say. Page 50. Accordingly, joint prayer has been made. Counsel for the petitioner as well as the learned counsel for the respondent 9, that is the present number 7. As the names of both petitioner and respondent number 9 appears in the list of details of teachers submitted by the respondent number 7. That must have so, and there is no dispute. Now, at that relevant point of time, there was an understanding since both the name of petitioner as well as the respondent were incorporated, showing the actual subject taught. But after disposal of this petition, the matter changed. That is why Lordship may interfere based on this order, 6/11/2020. Apparently illegal order. Because tomorrow, suppose they produce the record. Now, what new record they will produce? The earlier the wrong commission, that record will be produced. It will not change the direction of this honorable court and the admitted position of the respondent number 7. I am not concerned with the respondent number 8. Although I have made a party, in the meantime he retired. And he is the Arabic teacher. I am the senior most. I am the language teacher. Respondent number 7 is science teacher. So what more is required? And by filing affidavit also subsequently in this proceeding, he admitted, yes, I am teaching science. So that is why I repeatedly Lordship try to consider this order may be interfered. Otherwise, Lordship, again they will pass some order again, I have to come back this. In the meantime, I am at the verge of retirement. He is now 59 years old. There is nothing he will get. In 2020, he was 55. 2020, he again come back, 57, now 59. So that is why Lordship may kindly interfere with this provincialization order. Specifically in respect of restaurant number 7, illegally enjoying the benefit.
Restaurant number 7 or the
7.
person who have not made you property?
No, restaurant 7, Lordship, he is a party.
Another science teacher equal and condition is correct. That other science teacher have been go
Not required.
or Arabic teacher, they are the junior. Either Arabic teacher or science.
Okay, give me 5 minutes.
Right.
Heard Mr. Edeka. Land counsel for the petitioner. And Mr. NJ Khatania, right? PK Bora. Sorry, please me. PK Bora. Standing Council Elementary Education. 40 respondent numbers 1, 2, 3, 4, 5.
646, Your Worship.
Government Advocate Assam. 40 respondent number 6. Mr. F. U. Borby, Land Council for the respondent number 7. What's your good name? Speak Government Land Council for the respondent. Petitioner is agree. As the authorities in the elementary education department provincialize the services of the respondent numbers 7 and 8 as tutors. By order dated 05/02/2021 issued by the Director of Elementary Education Assam. Disregarding his claim for provincialization and service under the provision of the 2017 Act. It is stated by the petition. The respondent number 7. A science graduate. was serving as a teacher in Borjana. Mr. Borbhoya, NS Memorial means what? You are the head teacher. What is the full form of NS Memorial? Yes, madam. What is the full name of the school? Naimuddin Sardar Memorial Girls. MB Madrasa. In the Srijangram Education Block of District Bongaigaon. Since its venture stage. When I was teaching, was the rendering. I was teaching students, telling the students of the same in madrasa as a maths and science teacher. The respondent number 7 was appointed by the managing committee of the St. Vincent School by its resolution dated 03/01/1997. The respondent number 8 the class 12 passed. Teacher. The class 12 passed was appointed in the St. Borjana NSM Girls ME Madrasa by its resolution dated 10/01/1987. And joined service as the teacher of the said school on 11/01/1987. And was teaching subject of Assamese and social science to the students of the said Girls ME Madrasa. The petitioner, pre-university passed, was also appointed by the school managing committee of the said Borjana NSM Girls ME Madrasa by its resolution dated 10/01/1987 and joined the service in the said Girls ME Madrasa since its venture stage on 13/01/1987 and was teaching the language teacher of English, language subjects, English and Assamese to its students. The seven and 8 million. One Abdul Salam petitioner. Respond number. Pursuant to a decision of the resolution of the school SMC of the St. Borjana NSM Girls ME Madrasa dated 24/12/1987. The respondent higher secondary passed to Arabic joined the St. Madrasa, Girls Madrasa, Girls ME Madrasa on 27/01/1987 and was teaching Arabic, interior and art to the students of the said school. Another teacher, namely Tahirul Islam, was appointed by the school committee SMC of the said Girls Semi Madrasa by its resolution dated 15/07/2006. Tahirul Islam is higher secondary passed in science. And he joined his service in the said Girls Semi Madrasa on 17/7/2006 and was teaching Arabic subject, no, science subject. In addition to the correspondent number 7 in the say madrasa. There was another teacher by name Rashida Hassan, an arts graduate with Hindi, was also appointed by the SMC of Sikh Girls Semi Madrasa by resolution dated 15/07/2006. And she joined her service in the Said Madrasa on 17/7/2006 and was teaching Hindi. And art education to the students of the cities. Mr. Bora, in the Act 2017 Act, is there any specific provision that a candidate must have certain percentage of marks
In the 17.
for appointment of science teacher? Is there any provision?
No.
There is no such
There
provision.
is no.
Marks is not required.
Malad there. Malad as per the NCT Malad, but as per the 17 Act, not specific.
Is there any other provision in any other act, right to education act? Is there any provision of marks to be secured by, it is not there.
Malad there.
What is it?
NCT, National Research Eligibility.
What is the marks required for a science teacher?
45 million. 45%.
And what about the
Plus the
other higher secondary passed and all?
50%, Malad there. The secondary, Malad 45 and 50%, and
What about the
DLED
ME
and
schools, upper
Yeah.
primary?
upper primary, Malad, graduation is also with DLED or B.Ed, Malad.
But with regard to the provincialization under the 2017 Act,
Malad.
there is no such provision for following the NCT guidelines.
Malad, this will follow, Malad, August 23, 2010 notification of NCT, Malad. August 23, 2010 notification, Malad.
No. In the 2017 Act, there is no such provision that has to be.
Malad, only thing is that this NCT requirement is there, no?
Where? Which provision?
My lord, teacher, my lord, 104.
104.
My lord.
Definition of
Teacher
teacher.
means teachers, my lord. Teacher also include lecturer, professor, mentioned. Working venture education, having required educational and professional as per norms and standard fixed by the right to even right to children and free compulsory education 2009, National Council for Teacher Education 1993 under the University Grant Commission. And the relevant rule regulation framed thereunder.
No, tutor, all these persons have been appointed as tutors, right?
My lord, my lord.
So,
They have been not qualification to become a teacher.
right. Okay. All were appointed as tutors, so teachers.
These are.
All the four were appointed as tutors.
Tutors.
As the respondents in the elementary education. Including the District Scrutiny Committee, Bongaigaon, contemplated to appoint completed to provincialize the services of the respondent number 7 and 8. As tutors under the 2017 Act, without considering the case of the petition. He earlier filed a writ petition being WPC number 3031/2020, wherein the present petitioner, wherein the present respondent number 7 was the respondent number 9. In said WPC number 3031/2020, filed on 30/07/2020. The petitioner, amongst others, prayed for setting aside the illegal recommendation of the District Scrutiny Committee, Bongaigaon, taken in the month of January 2020, to the State Level Scrutiny Committee for provincialization of services of teachers of Borjana and as Memorial Girls ME Madrasa on the basis of staff pattern of said ME Madrasa, purportedly submitted by the said respondent number 7, the headmaster of the said ME Madrasa, deleting the name of the petitioner from the post of second assistant teacher with an intention to deprive him from the weight of provincialization and to direct the respondent state level scrutiny committee represented by the Director of Elementary Education Assam, as well as the Director of Elementary Education Assam, responding numbers 2 and 3 respectively, to dispose of his representation dated 24/02/2020, submitted by the respondent number 7, the headmaster of the said ME Madrasa, as well as to consider the letter dated 04/03/2020 of the District Elementary Education Officer, Bongaigaon, annexed to the said petition as annexes 6 and 7, by which the name of the petitioner was proposed for inclusion as eligible second assistant teacher of Borjana NS M Girls Semi Madrasa for provincialization of services. Etc. Next. In the said WBC numbers are and such. The petitioner annexed a letter of the headmaster of Bardana NSM Girls Semi Madrasa, dated 24/02/2020, as an assert 6. Submitted before the Director of Elementary Education Assam through the District Elementary Education Assam, Bongaigaon, indicating that said such and such a madrasa was established on 01/01/1993 with due permission and approval of the authority concerned, and it was recognized on 01/01/2005. And that the DEO of District Bongaigaon, with regard to the provincialization of the services of the teaching and non-teaching staff of the state madrasa, communicated on 17/03/2008. On the basis of which the proposal was submitted. But during such recommendation, the name of the petitioner as language teacher was inadvertently dropped. And therefore, by the said letter, dated 24/02/2020, the headmaster of said Girls Semi Madrasa requested the director of that requested the DE Assam through the DEO Bongaigaon to consider the case of the petitioner as language teacher and include his name for provincialization of service as per law. The said letter of the headmaster of Bardana NS Memorial Girls Semi Madrasa was also duly countersigned by the president of the SMC of the said madrasa. And over the said later, there are 24, signed on 27. The headmaster of the school, headmaster of the said madrasa, placed the staff pattern of the said girls madrasa, showing the petitioner as a language teacher on English and assemblies in the said madrasa. The petitioner, in his said WPC number such and such, also annexed the communication of the DEO Bongaigaon, dated 04/03/2020, whereby as an exercise, whereby the said DEO proposed before the DE Assam to include the name of the petitioner as an eligible staff of said Barzana NS and Girls Semi Madrasa for Provincial Health Services as eligible tutors. Referring the application of the headmaster of the said madrasa dated 24/02/2020, indicating that the present respondent number 7, the headmaster of the madrasa, was teaching mathematics and science. One Abdul Salam, assistant teacher, was teaching social science and Assamese. And the petitioner is to teach Assamese and English subject to the students of the second class. The present respondent number 7. Who by name was the respondent number 9 in said application number 2031. 2020. Being the headmaster of the said Rancher Madrasa. File an affidavit in the matter on 13/10/2020. While issuing notice. While issuing notice, the court on 17/08/2020 passed an interim order observing that till the next date fixed, the respondents were directed not to take any steps for provincialization of service of the headmaster of the said school in respondent number 9 therein, if not already done. Thereafter, which one number 5? The respondent number 9 therein, the present respondent number 7. Also filed an interlocutory application in said WPC number 3031/2020, being IAC 1766/2020. On 13/10/2020, praying for vacation, modification, or alteration of the said order 17/08/2020. Accepted. So the interim order dated 17/08/2020 was extended further by order dated 17. Any such a affidavit help I felt for vacating the order. 17/2020 or 2020. After hearing the petition, the respondents in the elementary education department, and the same respondent number 9, the present respondent number 7. The court on 06/11/2020 passed the following order. From the records of WTC number 3031/2020. As well as IAC 1766/2023 in WTC number 36. It is seen that the copy of the affidavit filed by the respondent number 9 within the present respondent number 7, as well as the application filed by the said, as well as the application filed by the said respondent being ISC 1766/2020. Copies are served on the standing council in Department of School Education. তার পাশে order হবে। See as follows. Though the court by order 6/11/2020 passed in the application number 3031/2020. In this said, I dated such and such. In this said, I number such and such. The respondent number 9, very applicant, applicant, very 9, the present respondent number 7. Annexed. A school verification format along with details of teachers' position, it says Barjana NSM Girls in Madrasa. Filed on 05032020. Reflecting the enrollment of the students class 6, 7, and 8. For the years 2017, 18, 19, 20, 21. Yes. Mr. Bora, just tell us one. You have appointed the fourth teacher
My lord,
on the basis of the base years up to 2020.
my lord, on the basis of my lord, student ratio, my lord, there
Student teacher ratio as on which date?
of 2016, 17 and 17, 18. In the year 2016, 17, there are 98 number of students. In the year 2017, 18, there are 118 my lord, students.
Not to 24. No.
But the record of district scrutiny committee, Lordship, it says 2014, 15 and 16. Page 434. The recommendation of the district scrutiny committee.
Yeah, that's it. The applicant doesn't respond. The next, school verification form, please apply to. Very important. The present petition was shown to be the second assistant teacher. And the applicant, and the respondent number 7 is the headmaster of the said school. Where the petitioner is which English in the and has the the diploma in elementary education. Was it point? And the respondent number 7. It's maths and science. While issuing notice in the present proceeding on 18/04/2022. The respondent authority is in the education department, elementary education department. Passing the said order. At 6/11/2022. The application number 20. By order dated 05/02/2021. Provincialize the service of the restaurant number 7 and 8 as tutors. And attach them. Restaurant number 7 as the language teacher. Restaurant number 8 as Arabic teacher. And one Abdul Salam as social science teacher. And Tahirul Islam as maths and science teacher. Since the respondent authorities in the elementary education department as well as district scrutiny committee did not consider the case of the petitioner, the provincial health service under 2007, in spite of the order of the court at 06/07/11/2022. Agree if the petitioner has filed this writ petition on 30/03/2022. Pay memo service. For a direction to the respondents in the elementary education department to reconsider and verify the grievance of the petition for provincialization of its service under the provision of Section 2017 in any base. And to set aside the provincialization order at the 05/02/2021 as tutors relating to respondent number 7 and 8. With the further prayer, the direction to the state level scrutiny committee Assam to verify the claims of the petitioner as well as respondent number 7 and 8 express under 2017. And of the for such others, such other orders as the 14th. In the interest of justice. Section 2 and 311. Net. Section 13. 11 or 30. Very mindful. To be mindful is only the provincial authority. Section 13(1), 2. Didn't make it 1, 13 will make it 2. 13 will make it 3. No, 13(1), 2, and 5. Provides for district scrutiny committee in the district separately for elementary, secondary, and higher education. So as to scrutinize the service records and other related issues of the serving teachers of elsewhere education institutions pertaining to provincialization of the service. As per subsection 6 to section 13 of the 2017 Act, the district scrutiny committee has declared at first is required to scrutinize and prepare a list of all venture educational institutions within the district which are eligible in terms of the provisions of the Act 2017, and thereafter to proceed to scrutinize and verify the service records of all the serving teachers who are eligible or would become eligible for being considered for provincialization of the services, where the district committee is also required to identify the school or each category of school and recommend the name or teacher of the tutor to be associated against each of such schools. 7 variety, 8 variety. Then 10 state level, 11 or 12 along with the explanation part. Though the respondents in the elementary education did not file any affidavit in this matter, in spite of issuance of notice on between 04/2022 for more than 2 years, 3 months, 4 months. Today, Mr. Bora and extended council, elementary education, placed a copy of the parawise comments represent the petition being sent by the Director of Elementary Education Assam by its communication with 0909. By order dated 04/01/2023, the court directed the authorities in the elementary education department invariably to place before the court the instructions pertaining to the factors basing on which the services of the teachers of the school were decided to be provincialized, and the reason why petitioner was denied the benefit of provincialization. The plan of the DE Assam in this petition is that as per clause 3, within bracket 1, within bracket Roman 11, the 2017 Act, minimum 3 teacher of the tutor in upper primary school, each for within bracket A language, B science and maths, and C social science. Is required to be considered for science for additional teachers as per the 2017 Act. Should be considered in accordance with the norms and standards stipulated in the schedule under sections 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009. As per the DE Assam, the DU Bongaigaon submitted the proposal for provincialization of services, recommending the respond number 7 as an English teacher of the same Madras, on Abdul Salam as the social science teacher, Taharul Islam as maths and science teacher, and the respond number 8 Abdul Qadir as Arabic teacher. And that the name of the petitioner was enlisted as non-recommended in the proposal furnished by the district scrutiny committee, Bongaigaon pertaining to Barzana, Naimuddin Sadar, and NSM Girls Semi School, Madras. It is also stated by the DE Assam that after receiving the same proposal from the DEO Bongaigaon, it was placed before the state level scrutiny committee as well as the joint committee constituted by the government under the chairmanship of R.C. Jain IS, chairman of SEWA, for examining the proposal for provincial service. Issued by notification dated 15/3/2019. The said committee constituted committee in its minute dated 24/07/2020 decided to instruct the managing director MD of the SSA Assam to verify the DICE related parameters of the school in concern. Roman one. Whether the name of the school appears in the DICE data maintained by the NU EPA New Delhi 2009 or before. 2. Whether the name of incumbent appears in DICE data maintained by NUP New Delhi of 2011 and afterward. And enrollment position of the school during 2016-17 and 2017-18. Pursuant to the same, the SSA authorities of Assam submitted a DICE verification report of the year 2016-17 and 17-18, showing the number of enrollment in the year 2016-17 as 98, and 2017-18 as 118. As per the enrollment position, the school, during the year 2016-17, the authorities concerned found that it said BNSM Girls Semi Madrasa is eligible for 4 teachers. As per clause 3 within bracket 1 of the within bracket Roman 11. One teacher each for language, science, and social science. Along with you, one additional teacher along with. The DSM categorically stated that the petitioner could not be recommended by both the state level selection committee as well as the committee constituted by the government by notification dated 18/2/2019. As the name of the petitioner was not recommended by the DSC. After recommendation of the board committee, state level scrutiny committee, the office of the DE submitted proposal to the government for creation of post of tutors. And accordingly, 4 numbers of post of tutors against the said BNS and Girls Semi School was sanctioned. Thereafter, the office of the DE Assam issued the provincial and service of response number 7 and 8 of the teachers and tutors. It is submitted by the DE Assam. The case of the petitioner could not be considered as his name was not recommended by the state level scrutiny committee as well as the committee constituted on such as his name was not recommended by the district scrutiny committee from my home. It is submitted by the DE Assam that the SLSC recommended 4 number of teachers of BNS and Girls in the Madrasa for following the provision of section 3 within bracket 1 within bracket 1 minute capital 1 11 Roman 11. The numerical one, bracket of the same 2017 Act. Based on the recommendation of the DSC Bongaigaon, but could not consider the application of the headmaster of the state Madrasa Girls Semi Madrasa submitted to the DEO Bongaigaon for inclusion of the services of the petitioner. Since the proposal was not submitted to the district scrutiny committee Bongaigaon as per clause 13(6) of the same 2017. Along with this said communication dated 09/09/2024, the DE Assam forwarded the recommendation of the BSc Bongaigaon wherein the name of the petitioner did not figure under the at clause 6 dash D. Details of tutor eligible for provincialization. Whereas his name figured in the said format at serial number 7 at clause 7. Details of teacher slash tutor who are not eligible for provincialization due to non-availability of required enrollment. In the recommendation of DSC Bongaigaon, the response number 7 was shown to be the headmaster and subject taught as English. Whereas the response number 8 was shown to be the assistant teacher teaching the subject of Arabic and Dinia. Leaving the petitioner who is to teach English and Assamese in the same matters, and one Rasida Hassan, Hindi teacher of the same school, for provincialization of this. Though the DE Assam stated that the DSC Bongaigaon, that the SLSC and the committee constituted by the government considered the recommendation of the DSC Bongaigaon for provincialization of services of teachers of the state Girls University. But the DE Assam being the chairman of the SLS, in spite of the order of the court dated 06/11/2002, passed in WPC number 3031 of 2023. Did not consider the dispute raised by the petitioner. Petitioner, wherein the headmaster of the school, the response number 7, clearly indicated that he used to teach maths and science, and the petitioner is to teach English and some little bit language teacher, because the English in science school, it also. It is already noted above that as per section 13(1), 13(6), the district scrutiny committee is required to scrutinize and verify the service records of all the serving teachers who are eligible or would become eligible for being considered for provincialization of this service. Though the authorities in the elementary education department were aware of the order dated 06/11/2020 in WPC number 3031 of the SLSC apparently did not inspect all the documents and records produced before it, nor call for such other records and documents as may be required for the purpose of following verification has been specified in subsection 11 of section 13 of the 2017. The SLSC headed by the DE Assam also did not comply with the provision of section 12 of section 13. Wherein it is provided that when there is a difference, when there arises a difference between the recommendation of the district scrutiny committee and the physical verification report caused by the state level SLS, the matter to be placed before the SLSC, where the decision of the SLSC and in its communication dated 09/09/2024, the DE Assam being the chairman of the SLSC in 2017 did not state anything that the state authority took any steps or initiative for verification of new records relating to provincialization of services of the response number 7, 8, and other to teachers. Though the dispute was raised by the DU of Bamaigaon in its communication dated 13, which was considered by the court earlier in its order dated 6/11/2020 costing application of 3. Since there is a judicial order of the court dated 06/11/2020 costing the application of 3031 wherein the respondents in the elementary education department are the party respondents. The court is of the view that any such provincialization done by the respondent authorities in the elementary education level relating to the respond number 7 and 8 in state needs to be interpreted for non-compliance by the SLFC as required under subsection 12 or section 13. Section 11 and 12. After hearing the council for the parties and considering the entire the chairman of the state level scrutiny committee, I, the director of elementary education Assam in the present case, is directed to verify the entire record relating to Kulsnam Pradiva, Barzana, Neighborhood Charter, Memorial Girls and Madrasa. Appraise and to do the needful as per the provisions of the state 2017 Act. Or provincialization of the concerned teachers of the said Girls Semi Madrasa as tutors. In that regard, after the verification of the documents and records of the with the report of the press report of the DEO, DEO as well as the communication of the DEO under number circumstances. Shall pass a speaking order within a period of 3 months from today. Within a period of 3 months from the date of receipt of certified copy along with the presentation copy. Certified copy is available. Informing the petitioner about the outcome of said press verification. The petitioner shall submit the certified copy of this order along with the representation before the DE Assam on or before. This the state level and selection committee, scrutiny committee, headed by the DE Assam respond number 2. If so required, may hear the petitioner, the respond number 7 and 8, as well as the other 2 teachers other teachers already considered for provincial action pursuant to the TAC provided of report. And the other teacher not been recommended, and the teachers not been recommended by the TAC for provincial village services activities relating to the teachers and staff. As well as the EO, who is the member secretary for the district scrutiny committee, has been provided under section 13, 18 bracket 3, 13 in bracket 5. Till such issuance of speaking order within the such time has been directed above. And the respond number 7 and 8. That be allowed to serve as students in terms of their order of appointment dated 5 to 7. If during such inquiry by district level selection committee, the petitioner is found within the such specified time, the petitioner is found to be eligible for provincialization as due to in said Bardana and as M girls and boys. The authorities concerned, including the respondent numbers and 2, shall do the needful. Keeping in consideration that the petitioner shall retire from service in July 2025 on attaining the age of superannuation lecture. Copy of the communication dated 09/09/2024 placed by Mr. Bora before the court today be kept as a part of it.
One submission only. That instead of director, it should be the state government lordship. Because I am agree by both the recommendation of, because the 6 and 14, it says the state government is the concerned administrative department. Because already you lordship has seen the director has not considered the Givasoni petitioner. So there is doubt lordship he again considered. So that is also kindly see for 14 appellate authority. The state level scrutiny committee shall be the appellate all authority against any recommendation of the district level scrutiny committee. Lordship, pause for a moment here, Lordship. Here, Lordship.
We are giving it to director because the power allows section 11, 13, 11.
That is up to the recommendation made by the district scrutiny committee. But here it is a case, they go ahead They recommended the state level committee, I will also kindly see section appellate 30, section 14. It is clearly given, state government. The state level scrutiny committee shall be the appellate authority against any recommendation of district scrutiny committee, and the state government in the concerned administrative department shall be the appellate authority against any recommendation of state level scrutiny committee. So here it is a case recommendation made by the state level scrutiny committee. So that is why this secretary is the best authority, Lord, because he is the concerned administrative department. So Lordship may give a direction to the secretary of the school education department instead of director. But the rule 14 clearly says against any recommendation of state level scrutiny committee. Instead of director, it is the secretary only.
Secretary, the government of Assam in the education elementary. Commissioner secretary. Is there any commissioner?
No, nowadays it is known as portfolio known as secretary, Lord. Secretary of the school education. And the appointment of referee is subject to outcome of the speaking order, Lord. What's the time frame is,
3 months.
3 months, let's say, he is going to retire. Let it be 1 month. Lord.
3 months, because it's in Bongai, 2 months will be too less.
Lord.
You are aware?
Apply, Lord.
Obligation. Where is Mr. Sisti?
I think Mr. Sisti has left. Yes, entered.
Where is Mr. Sisti?
Lordship, when the petitioner was working, Lordship, may I start? Lordship?
This rule 24,
Rule 24(3), Lordship, yes.
3 or 5,
Rule 24(5), Lordship.
2018 rule.
2018 rules.
Which page of the book?
Lordship, page 42 of this book, Lordship.
Yes.
Rule, in case of amalgamation of ME, MB, LP school with other higher secondary school, high school, under the scheme 6 Act, the employees of the amalgamated school shall be given seniority with effect from the date of joining on substantive appointment or regularization. Lordship, I was initially appointed in the ME school on 17/6/1992, and I was regularized in service in the year 1994.
Amalgamated with which school?
Amalgamated with Vivekananda Vidyapit High Secondary School.
Higher secondary?
Lordship,
Yes.
in Bongaigaon district. And my service was regularized on 21/3/1994. And during the ME school, Lordship, I was subjected to several transfer and attachment orders. That every order I have complied. That is not relevant here, because the rule says it is the substantive appointment. That is since I was appointed in the year 1992, that would be relevant also.
Where you are reading? Rule 28.
Rule, Lordship, yes. Rule 24(5). Page 42 of the book. Lordship.
Where is the amalgamation?
Amalgamation order, your lordship will find that page 61. It is of 27/6/2017. My name appears at serial number 6.
Page 27.
Page 61 also of the writ petition.
Where is your appointment order?
My appointment order is at page 19, lordship. I was appointed as a science graduate teacher. In fact, lordship, my case is squarely covered by the judgment rendered in the Minaram Kumar lordship. Even the division bench has also held that the services of the science graduate teacher, the past service cannot be wiped out. And also even the rules, the rule 24(5) also says that also it will be suspensive appointment or death of regularization. I am 4 years, 3 months senior to the respondent number 4.
What is your grievance? What is your grievance?
My grievance is, lordship, I have challenged his appointment as the in-charge principal and lordship to decide the seniority between the petitioner and the respondent number 4. Now, lordship, there is the latest development, lordship. Lordship, I have filed a reply, affidavit in reply on 21/7/2024. Now, lordship, they have published the gradation list. Lordship, may kindly see my affidavit in reply at page 108. In the gradation list, lordship, now this gradation list has been published in terms of the rules and lordship, the judgment rendered by Justice Honorable Justice Ujjwal Bhua in Nagoni Borua's case, wherein lordship the gradation list was to be published in the every year, lordship.
Now, Lordship, in the gradation list, Lordship, my name reflects at serial number 37, seniority position number 37, whereas the respondent number 4's name is at serial number 106. And the respondent number 4 has not challenged this gradation list. This, although this is a graph gradation list, but in terms of the gradation list also, Lordship, my name appears marks above. My name appears at serial number 37. And his name appears at serial number 106. Your Lordship will find at page 109 and 110 of the affidavit and reply.
The respondent,
Respondent number 4's name appears at serial number at page 110, Lordship. Abdul Razak, principal insert. This is a type copy, Lordship. I have also given the original one.
when did you pass MA?
MA, I have passed, Lordship, in 2021. Although I took admission in 2016. And I took permission from the DIF school because at that point of time, my service was under the DIF school. Also.
Yes, who is from the education?
Lordship, may I place the judgment of Minaram Kumar, Lordship? Both the
Reported judgment.
Yes, Lord. Minaram Kumar is 2014 5 GLR 392. Tata saise mark kore dia. Tata janake mark kore. Hey, itu lah.
What is the stand of the government?
End of the government lordship, they have filed one affidavit. They have tried to question lordship but that issue has also been settled also by this honorable court also. With regard to my qualification. And lordship, they have also raised one, that my one transfer order is not found with regard to my transfer from Atugaon MB school to Vivekananda Vidyapith. That lordship I have explained in my affidavit in reply, and that is also reflected in my service book, which I vanished in the writ petition.
And place that report, my lord, received from the inspector of schools, my lord, pursuant to the order that was passed by the honorable court.
ইমান ডাঙৰকে নকৰো। দেখাত কৰোঁতে আকৌ নল'ব পাৰে এনেকে।
Any order from the court earlier?
Lordship?
Any order from the court earlier?
Yes, my lord.
Lordship,
28th of August,
yes,
my lord, the
Mr.
order
Srishti
dated
was,
20/08/2024.
Yes, 28/8.
20/08/2024. This honorable court directed us to produce the transfer order dated 8/3/2001.
Lordship, that particular transfer order is reflected in my service book at page 36. It has been recorded.
পিছত 12 দিন পিছত এখন নতুন অর্ডার ওলাই গৈছে। সেইটো relevant
Relevant. Lordship, my humble submission, Lordship, my earlier transfer orders, Lordship, that has no relevance here.
Very much relevant, my lord. That's why this honorable court called
Because
for this, my lord.
as per rules, Lordship, it is the substantive appointment, and my substantive appointment is in 1992. That should be considered, Lordship.
This decision of the court as another challenge. Brother Buzurburo's order is under challenge in appeal.
No. Oh, that issue has been settled also. This honorable court has given stay order in all the cases. That issue has been settled. Permission.
Subsequently, my lord, it was followed in several other orders of by these coordinate benches, my lord. নাই ৰিপৰ্ট সেনেকে আহিছে না সেইখন স্কুলত আছে না ডাইৰেক্টৰ ভিতৰত তাতে সেনেকে
Which transfer order you are talking about?
Lawsuit, the transfer order also, they have insisted that I should produce it. That has been already reflected in page 36 in my service book lawsuit.
তাৰমানে সেইখন অৰ্ডাৰ দিলে ইয়াৰ তাক জইণ্ট কৰিব নিশ্চয় তাৰপিছত 30 দিন পিছত 12 দিন পিছত আৰু এখন নতুন অৰ্ডাৰ পিছৰ ৰুম কিন্তু পাব্লিক
Yes, what is the stand of the government?
The affidavit that has been filed by the director, my lord, as per para 7 of that affidavit, the reason for giving the charge to the respondent, private respondent, my lord, was in view of Rule 13 of the 1965 Conduct Rules, that the permission was not obtained. Though he made an application to the DO, and the DO made in the application say may be allowed, but there was no formal permission for obtaining the degrees, and therefore he was not given the charge, which possibly, my lord, now in view of the decisions rendered by this honorable court, that it will not invalidate the degree, my lord. So that ground may not stand there.
So, considering him the decisions of this court,
My lord.
the draft seniority list has been prepared.
Yes. In the draft seniority list also, my lord, will find, my lord, it is shown in the draft seniority list that the permission is obtained from the DO. In the column, if qualification acquired in service period, please state whether previous permission NOC from the appointing authority was obtained or not. It is indicated as yes, DO permission for MA.
When did you obtain MA?
What's it?
When did you obtain MA? Master degree?
Master degree.
Master degree I have obtained finally in lawsuit 2021. But I took permission, yes, I took admission, that is from lordship in distance mode from Krishnakanta Handy Open University. I took admission in 2016 when my service was under the DO lordship, because the school got amalgamated in 2017. But I finally passed in 2021.
You are the in-charge headmaster of the ME school.
I was the in-charge principal of the high secondary school.
When the amalgamation took place.
In 2017.
Yes.
Yes, I was, for some time, let's say, I was appointed as in-charge, but I am just coming.
Yes, now, what? Mr. First tell us what to do.
Yes, assistant teacher.
My lord.
DL number 6, page 61.
Rule provides seniority to be counted from the date of
Substantive.
post.
Lotsie just made a query,
Seniority may
at
not
page
be-
63, page 63, Lotsie.
My lord, I'll explain, my lord. Seniority is, my lord, very important.
Page 63, Lotsie, the earlier, Lotsie just put a question.
You have seen that, that is why we asked. Yes, Mr.
My lord, in terms of the gradation rates, my lord, it appears, my lord, seniority is no more a dispute. My lord, the petitioner appears to be the senior, my lord. The only ground which in para 7, that also possibly, my lord.
It has been settled by the court.
Yes, that is settled. So
So
possibly the director has to review the order, my lord, in terms of.
yes, Mr. Mohanta.
My
You are referring for
lord,
the-
see, first of all, my lord, the transfer order which was, my lord, bearing the everything, my lord, that is not been produced before this honorable court. And that was made missing, my lord. Your lordship kindly see, there is a personal hearing before the director. He was unable to produce that order. My lord, he is suspensive, my lord, my lord, seniority will be counted in amalgamated school because he was transferred to Vikas Vidyapit, my lord. Vivekananda Vidyapit. When? 2001. So it was, my lord, it was his own request. Since it is a own request, there is a judgment of the High Court. He will not carry seniority, past seniority, my lord. So that's why it is, my lord. I have specifically mentioned it was not passed in, my lord, public interest. He has not answered. Now, my lord, everybody says it is missing, missing. Now, my lord, by virtue of the, my lord, that's why your lordship kindly see, suppose that amalgamation was done in 2017. And he appointed in the school and he's come to this school, my school, because I am from very beginning, I am in the higher section, my lord. I am in high school.
You are the subject teacher, necessarily you will be in the.
My lord. And I got the master degree, I got the graduate skill from the very beginning. Because I got the master degree also, my lord. So from my date of initial appointment, it is 1996. So the Vivekananda Vidyapit ME school, that was amalgamated 2017, and he came to this, my lord, Vivekananda school in 2001. But it was his own request. And that is why his service, my lord, seniority will be counted in that school from that particular date. That is why, my lord, this honorable court specifically asked them to produce that order, my lord. If that order is, my lord, in public interest, my lord, then he will claim the seniority as per amalgamation rule. Now, my lord, they claim seniority by virtue of, my lord, draft selection, draft gradation list. My lord, already several complaints have been filed. No final gradation is yet to be published. So until and unless, my lord, final gradation is published, I cannot challenge it, my lord. So that is my submission, my lord. That's why in order dated, your lordship kindly find this honorable court, my lord, on 28/8/2024, specifically asked the government to produce that order. But why that has been missing, my lord? Neither in the office of the director, nor in the inspector of school, my lord. Strange, my lord. If that's, he can show that it is a public interest and that transfer order placed before his honorable court, then, my lord, question of amalgamation rule will be followed, my lord. Otherwise, my lord, his seniority will be counted from the date of 2001, my lord. Assuming that he has joined in the school, my lord, from his own transfer was made on his own interest, then, my lord, seniority will be counted from that date. In that event, my lord, he is junior to me, my lord. If inspector of school says that it is not been, my lord, found nothing in the record, my lord, let them file an affidavit that it is not there, then they will take action, my lord. official record, it has to be, my lord, keep for at least 30 years.
Yes, you just tell us one thing. Rule 24(5) of the 2018 rule.
Rule 24(5).
Page 42.
Yeah. In case of amalgamation of ME, MP, LP school with others higher secondary high school, a scheme of 6, etc., the employees of the amalgamated school shall be given the seniority with effect from the date of joining on substantive appointment or regularization, provided that in case of graduate teachers, the seniority shall be counted from the date of getting salaries meant for graduate teachers. They provide well, this seniority will be counted from the date of appointment, and in case of petitioner, his date of appointment in the graduate scale of pay was 17/6/1992, which was subsequently regularized on 1994.
So he was appointed in a substantive post when?
Regularized on 21/3/1994.
So his seniority be as per this rule 24(5), he should be considered for seniority from
17/6/1992.
No. It was regularized only on 21st of March.
Sorry, 21st of March 1994. Page 25, Annexure 4.
That's right. Now, as Mr. Mohanto is saying that his seniority in the school will be from the date of joining, that is 2021.
If Lordship finds
Seniority of the school, the language your lordship can be free. 24(5), my lord, 24, my lord.
Yes.
In case of amalgamation, the ME, MB, LP school,
With
other higher secondary school, high school under the scheme, etc. Employees of the amalgamated school shall be employees of the amalgamated school shall be given seniority of effect. Amalgamated school seniority, my lord. His past seniority, my lord, that is the, my lord, tax of the matter. He has transferred to his school in that school 2001. If it is public interest, then only get that seniority, my lord. Past seniority, my lord.
Shall be given seniority with effect from the date of joining.
on substantive appointment
Substantive appointment or regularization.
or regularization.
Here the question of
No, that is a question of, my lord, seniority
Substantive-
between the school.
not in the school, that's the reason. Read again. In case of amalgamation of ME, MB, LP school with other higher secondary.
With
school-
other high secondary.
With higher secondary school or other higher secondary school or high school under the scheme of Shiksha Kshetra. The employees of the amalgamated school shall be given seniority.
Yes.
With effect from the date of joining on substantive appointment. In the concern, LP, ME or MB school did not mention. It was mentioned that in the substantive post. Date of joining on
My lord.
substantive post, not on in the particular LP, ME or MB school.
If I'm not wrong, my lord, if it has to be the substantive appointment means if the initial appointment itself is a substantive appointment in that
And
school.
from that case.
Yeah, from that
Yes,
case.
whether from it is school in the Bongaigaon district or from.
Or anywhere, his initial appointment.
This,
or if-
this means his appointment is substantive
Yes,
post
and
the petitioner.
And if it was on the temporary, and then in case that case regularization. Because there's a or, my lord.
And regularization was done. And regularization was done on 21st of March.
March 1994. And this amalgamated only with these conditions only that we will carry our seniority from the date of our initial appointment.
That's what is specific.
And I have received graduate scale of pay from the very first day, Lordship. Yeah, I being assigned as a teacher.
Mr. Mahanta, you want to add anything?
My lord, no, your lordship kindly see there, what is their condition in the amalgamation, my lord.
Yes.
And that mean, my lord, that is, my lord, it goes against to the, our, my lord, division bench, full bench judgment, my lord. If it is in, my lord, his own interest, and that school, my lord, he.
See, no doubt.
That mean, my lord, in amalgamation, your lordship kindly see, amalgamation, person, my lord, who is joining in, but just, my lord, few months ago in the amalgamation in that particular school, and then he also got the seniority, my lord.
That's what the rule says. Says that from the date of joining or on substantive post,
My lord.
appointment, or regularization. From
No,
the date
that-
of regularization, or you have to read a date of substantive appointment. Petitioner was substantive appointment earlier, but it was on ad hoc basis.
My lord.
So he was regularized March 2020. I think
21/3/1994.
21/3/1994.
Well, in respect of that transfer order 83/2001, possibly, well, this will be relevant. Your lordship comes to page 25, page 45. As per the report that I have placed, my lord, it says that after the transfer order 83/2001, due to public protest, he could not join and he was attached by this page 45, my lord. Page 45 of the repetition, my lord, find that. In the interest of public service, so-and-so who was transferred from so-and-so to Vivekananda Vidyapith, while order number 83/2001 is hereby attached at Calabari with immediate effect. So this indicates, my lord, in public interest, he was transferred on 83/2001. Subsequently, as he could not join due to the public protest, he was attached with some other school, my lord. And page 46, my lord, finds thereafter, my lord. That attachment was cancelled and he was brought back to his original place of posting at Vivekananda Vidyapith ME School.
First day order.
May I place one short judgment also, one page in the Supreme Court judgment also. And Minaram Kumar's judgment I have got.
Just give the citation. Okay, give it to us, give it to us.
Minaram Kumar 2014 5 GLR 390.
5 GLR.
2014 5 GLR
5
390.
GLR, it is in GLT also.
Yes.
GLR, how much?
2014 5 GLR 390. And also the division bench order is not recorded. I have the copy also. That was carried into appeal.
That is,
Okay.
my lord, no dispute here. Because, my lord, that degree is not been challenged, and, my lord, he can, authority can, my lord, proceed with against him, my lord, for disciplinary proceeding, not taking permission. But degree cannot be, my lord.
May it please, your lordship.
All right.
Lordship, item 12 to 16, 4 matters, lordship. Can it be possible to take up this matter tomorrow, lordship?
16 more.
I am out of service, lordship. No salary is.
Day after tomorrow.
Lordship.
16, 17, 18 also.
Item number 22, very similar to today's item number 6, my lord, section 14 of appellate authority. It's an interim order operating against me, my lord. Can it be on 24th, my lord? Stay vacation, my lord. This summer.
Day after tomorrow.
Obliged.
16, 17, 18 also.
12, 13, 14, 15
ষোল্ল
চাৰিটা।
ষোল্ল
আপনার
অ
12 to 15
16 16 17 18
12 তারিখে হবে।
এটা প্লেস চিনিয়র নাহে